All right, good morning, everyone. Are you able to hear me? If you are, please give a simple thumbs up, one person. Thank you. Are you able to hear me?
Yes.
All right, wonderful. This is the state all-purpose calendar in the state court of Fulton County, Georgia. I am Judge Melanie Williams. At today's calendar, we will handle several matters, hence on purpose. We will take pleas, arraign cases, conduct bond hearings as necessary. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. All participants, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch this proceeding. It is my understanding that several members of the Public Defender's Office have not had the opportunity to interview their clients prior to this morning's calendar. It's my hope that we can handle this as expeditiously as possible. I do not see Mr. Bartels on the screen. I see his email or Mr. McLean. Are either of them on the screen?
Good morning, Judge. I have Mr. Bartel here inside of courtroom 2.
Okay, wonderful.
On his way. So they'll be doing here from the court.
All right, wonderful. All right, who do we have first?
This is going to be position 20, Mr. Morgan. Mr. Bartel, is this your case? Position 20?
That is my case. Let me get this paper.
Mr. Bartels, we can hardly hear you as well. You're not close to the.
Have a seat here. Have a seat here and then you do this.
Right.
Okay, yeah, good morning, Judge.
Good morning, Mr. Bartels. Good to see you.
Yes, Your Honor. I did speak with Mr. Morgan, and just to give the court some background, I did send an email.
Before you do that, I do want to read him his rights. But what is your announcement for this case, Mr. Bartels?
Well, it will be a non-negotiated plea, Your Honor. I do need to get some clarification from the state. He's got 2 charges, 2 versions of the battery, apparently based on the same allegation. And I need to get some indication from the court or from the state if they're agreeable to him entering a plea to the battery family violence.
All right, 1 second. Mr. Morgan, your case is 22 CR 00583A. Is that correct? Yes. And in this case, you're charged with battery family violence and battery against a pregnant female, each with the offense date of November the 2nd of 2021. Do you understand your rights, Mr. Morgan?
Yes, ma'am.
All right, thank you. And Ms. Backus, is this your case?
Yes, Your Honor. Good morning.
All right. Mr. Bartels, did you want to speak to Ms. Backus off the record?
Yes, Your Honor, if possible.
All right, Ms. Backus.
Your Honor, I don't know if that's necessary. I think his question is simply that we still can, but I think his question is about the fact that the incident has brought 2 charges.
Yes, ma'am.
And they can merge into the battery family violence.
Okay, yeah, that's what we were asking about. And let me get my paperwork.
Okay.
All right, so is the plea now negotiated?
Hey, Mr. Posey, you got to keep your mask up for me.
Okay, Your Honor, I have the paperwork in my notes.
All right, now is it now negotiated, Mr. Bartels?
That is correct, Your Honor. He is basically wanting to agree to all the terms of the state's offer, except just get credit for the time that he's already served here.
All right, we'll see what happens. All right, Ms. Backus, if you would give us the factual basis very briefly, as well as the state's offer in this case.
Yes, Your Honor. This incident occurred on the 2nd of November. An officer was dispatched to Southern Regional Medical Center. The officer made contact with the caller who advised that she was at the Travel Lodge at 2471 Old National Parkway with, I believe, room 117 with the father of her unborn child. She was pregnant, and the defendant, when she saw him texting another female on his phone, she told him that she was leaving. He got upset. She said he stood up and punched her in the ear. She then said she went down and covered her stomach, and that's when he punched her 5 times with a closed fist in the face. After that, he let her up, and after he calmed down, but then he started getting aggressive again and knocked her down and then punched her in the face again. She said she had to pretend to have a seizure and acted if she was severely injured, which made him finally stop. And then he got her up, took her to the hospital. An officer did observe swelling and redness, I believe on her right eye. The history on this, Your Honor, he's got 40 cycles. I particularly paid attention to the last 10 and violent offenses. He does have a 2007 battery family violence. He also had, well, it's a 19, no, we're not going back there. 2004 armed robbery, a 1997 armed robbery. He's got a 2019 battery family violence, right? And so he has a violent history, which is why the state would not be amenable to lowering. Our offer on this case was 12 months, 90 days to serve, credit for time served, 14 days, balance probated, the FFIP, no further contact with Makosha Shivers. Makosha is spelled Makosha. Shivers is Chivers. A third-party transfer of the child and a one-time police escort if that's necessary.
All right, and the incident location was, sorry, I didn't catch the entire thing, Ms. Backus.
That was at the Travel Lodge. That's 2471 Old National Highway. I'm not sure if they reside there or if they were just staying there at the time. And so I don't know if a stay away is necessary.
All right, thank you. All right, Mr. Bartels. So your request is that the plea be time served.
With served 28 days, Your Honor, with credit for time served that he's already been in, and then the balance would be on probation. That is what we're asking for. I have not had an opportunity to review a GCIC, but I believe at least several of the charges referenced by the state were dismissed rather than resulting in a conviction. He is on probation in Pike County for a fleeing and eluding case, I'm told. And I'm also told that he had a probation violation as a result of this arrest. I'm advised that he served an additional 45 days in a probation detention center in Macon as a result of this arrest. And Mr. Morgan wants the court to take that into consideration as well.
All right, so I'm sorry, Mr. Bartels, you said he served 25 days in Macon and then the rest I couldn't hear.
I'm told 45 days. And he's asking the court to take that into consideration as well.
And that was on a different charge?
Well, he was on probation for fleeing and eluding, but I'm told it was a violation based on this arrest.
Okay. All right, if your client takes the plea today, Mr. Bartell, I am going to accept the state's recommendation. How many additional days would he have to serve in the Fulton County Jail?
Well, it would be 90 days. If he were to get 2-for-1 credit, that would be 45 days minus 14.
All right, does your client want to take the plea
Let
today?
me talk with him a moment, Your Honor.
All right.
Good morning, Judge.
morning,
Now my
Mr.
math may not be the best, but the defendant did not just get there yesterday, did he?
No.
Oh, he'll be receiving the time that he served in the Fulton County Jail. So I don't think he will have to serve an additional 90 days to answer your question.
No, I don't think so either. He would have to serve, he served 14 days already. Is that correct? I know Odyssey is not working, but I wanted to confirm the number of days.
I believe he would have to serve another 30 days, 31 days.
All right.
So you will.
That's my calculations as well, 31 days, Your Honor.
All right, thank you.
Your Honor, my client indicated that he would agree to the state's recommendation with the 90 days.
All right, we will go forward then. All right, Mr. Morgan, please raise your right hand. I'm gonna place you under oath for the very limited purposes of taking this plea today. All right? Do you swear and affirm that the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Man.
All right, thank you. All right, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
It doesn't, are you sure your client wants to take this plea today? Mr. Bartels, it does not appear that he wants to.
Well, I've advised his options. He indicated yes, but I concur with the court that there appears to be some reluctance.
Mr. Morgan, do you want to take this plea today?
Man, yeah, ma'am.
Are you sure this is, if I determine after answering these questions that you don't voluntarily take this plea, I'm gonna reset your case, okay?
Yeah, perhaps
All right.
that might be the best thing, Your Honor, given that with the court sentence, he would have to serve additional time anyway.
Well, the issue that I have, Mr. Bartels, is I don't want him to come back and then I've made this decision. So he would take the plea and my sentence recommendation would still go forward. What I don't want is him judge shopping by resetting it to next week. But,
I hear what the court's saying.
all right, so that what I would do is if we can reset this, but if he takes the plea next week, I'm gonna ask that the notes be put in that I did accept the state's recommendation and the sentence will be the same. So do you still wish to reset him to next week? Which I don't have a problem doing, but the sentence will be the same.
I'm unable to determine what he wants, Your Honor, so out of an abundance.
All right, we will reset him to next Thursday's SAP calendar. I'm making a note that the state's recommendation was accepted in this particular case. All right? So, Mr. Morgan, you will be back before a judge next Thursday. All right, that concludes your case for today. Oh, next Thursday is Thanksgiving. I apologize. So it will be the following Tuesday. So whatever date, let me look and see what day that is.
That will be November 22nd, Your Honor.
Yes,
No, I'm sorry, the 28th.
29th. It'll be the 29th.
29th, yeah.
We're gonna reset him to
Not
the
help.
20. Yeah, we'll reset him to the 29th. No one wants to come on Thanksgiving. All right, so Mr. Morgan, we will see you on November the 29th. Best of luck to you, sir.
Position 26, Posey.
Let me get my paperwork.
How you doing? Yes, ma'am. How you doing?
All right, good morning, Mr. Posey.
Yes, ma'am. Good morning, Mr. Judge Williams.
All right, your case is 22 CR 007566Y. In this case, you're charged with criminal trespass with the offense date of November the 3rd. Do you understand your right?
Yes, Judge Williams, ma'am.
Thank you. All right, who represents Mr. Posey?
That is my case, Your Honor.
All right, Mr. Bartels. All right, and the announcement I have is that this is a non-negotiated plea.
That is correct, Your Honor.
All right. Let's see, Ms. Campbell, please give me the state's recommendation as well as the factual basis and history if you have it.
Yes, Your Honor. The factual basis for this plea is that on the date of November 3rd, 2022, at approximately 2:59 a.m., officers were dispatched for a call of criminal trespass at the location of 855 Peachtree Street, which is a quick trip. Upon arrival, they spoke with the reporting party and they learned that the defendant in this matter, later identified as Michael Posey, came into the store at approximately 2 a.m. and he stole some beer and attempted to flee the location. They were able to get the beer back and detain him. And they later learned that he was issued a criminal trespass notice on October 25th, 2022 by a different police officer, and he was warned not to return to that location. So that is the facts for this particular matter. As far as the defendant's history, he does have 99 cycles. The most recent being a March 2022 arrest for robbery by force. He also has a January 2022 simple battery family violence conviction, a 21 conviction for simple assault, 21 conviction for simple battery, 2020 arrest for aggravated assault and armed robbery, a 2020 conviction for felony terroristic threats, a 2019 probation violation, 2018 theft by shoplifting conviction, 2018 criminal trespass conviction, 2018 probation violation, and a 2015 arrest for criminal trespass, as well as felony terroristic threats. That's his most recent history. There's more, but that's just since 2015. And the state's recommendation in this case was 12 months to serve 45 days, credit for the time served 15 days, the balance to be suspended, and that he is ordered to stay away from the Quick Trip located at 855 Peachtree Street.
All right, Mr. Bartels, I'm assuming that your contention here is the jail time.
That is correct, Your Honor. He understands that he cannot go back to this particular location.
Yeah, ma'am.
He's been in, I show a booking date of November 3rd. This will be 15 days. So if he is to get 2-for-1 credit, then we would ask for 30 days rather than 45 days. My client indicates he's 57 years old, that he works full-time as a manager at the Dunkin' Donuts at Lindbergh and Piedmont. He indicates he has 2 children that are 8 and 7 years old. And given all that, we would ask the court for that sentence.
All right. At this time, if the defendant chooses to take the plea today, I will accept the defense's recommendation. And it would be a sentence of 30 days, credit for the 15 days. And he would have to stay away from that that Quick Trip in its entirety, 1,000 yards away, sir. Does he wish to take that plea today?
Yes, ma'am. God bless you.
All right, let's ask you some questions, Mr. Posey, to make sure this is a voluntary plea. Please raise your right hand.
Yes, ma'am.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am. I do, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time, Mr. Posey?
No, ma'am. I am not.
Are you satisfied with your attorney's representation?
Yeah, absolutely, ma'am.
All right, and do you understand that by pleading guilty today, you're giving up your right to any further court dates regarding this criminal trespass charge?
Yes, ma'am. I do, Judge.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, Judge.
All right, and you understand that you absolutely cannot go back to that location?
Yes,
That you
I'm
need to
never
stay
going.
1,000 yards away. You're never going back there? All
Never
right.
going back. Never going back.
They do not want you back there. If you go back there, you'll be right back here with me. You understand that?
Yes, Judge Manley Williams.
All right, as to the charge of criminal trespass, Mr. Posey, how do you plead?
I plead guilty, Judge Manley Williams.
All right, I accept your guilty plea. Is there anything further from the state of the defense at this time?
Nothing,
Your Honor.
I can get the court and the clerk's office the paperwork when I get back to the office.
All right, thank you. All right, best of luck to you, Mr. Posey. That concludes your case, all right?
Thank you, Judge.
Ma'am, is it time, sir?
Yes, you're done.
Yes, you're done, sir.
I go home today?
If you don't have other holds, you should shortly. I don't know how quickly the jail will be able to release you, but if you don't have other holds, this case is no longer holding you in Fulton County Jail, all right? Don't go back to that store, though.
Thank you, Your Honor.
God bless you.
All right, take care.
I know, I'm gonna take you back. Thank you.
Positions 9 and 10, Mr. Fowler. Come on, Mr. Fowler. have a seat. Or 9 through 12.
Yeah, he's got 9, 10, 11, and 12. I have the announcement. It's TBA. Mr. Bartels, what's the announcement?
Yes, Your Honor, I did speak with Mr. Fowler. He indicates that he does want to accept the state's offer. I believe it's a global resolution for time served for all four of those cases.
Okay, so he's actually served all the time required, just, okay.
Right. The offer is 365 days and he's been.
Yes, understood. All right, Mr. Fowler, I'm gonna read you your case numbers. You have 4 cases. Ms. King, once we go through the facts, very briefly, I just asked for a quick line for each one. Thank you. All right, Mr. Fowler, your cases are 21 CR 001840A. You're charged with criminal trespass in that case. In case 21 CR 002122A, you're charged with obstruction of a law enforcement officer and criminal trespass. That offense date is April the 28th of 2021. The previously read criminal trespass case was February the 12th of 2021. In case 22 CR 007597A, in that case, you're charged with criminal trespass with the offense date of November the 4th of 2022. And in case 22 CR 006336A, you're charged with criminal trespass with the offense date of February the 13th of 2021. Do you understand your rights today, Mr. Fowler?
Yes, ma'am.
All right, thank you. So, Ms. King, if you give me a very brief summation as well as the state global offer for all of these cases and any pertinent history here. Thank you.
Your Honor, the global offer is 12 months to serve, 365 days, credit for time served, 334 days. So the first case occurred at the Dunkin' Donuts on 120 Piedmont Avenue. He had previously been criminal trespassed and returned to the location. The second case happened at the racetrack at 120 Piedmont Avenue. It appears like this is a plaza that he frequents. The same instance happened. He had been criminally trespassed and returned to the location. When officers tried to detain him, he tried to fight away and they actually had to tackle him to the ground to keep him from running away. The third case also happened at Dunkin' Donuts. So at this point, he had the open case, the criminal trespass. He returned. He was taken into custody then. And for the last case, that one also happened at the Dunkin' Donuts. He has a 2020 shoplifting conviction, a simple battery criminal trespass obstruction conviction from 2020. He also has a criminal trespass from 2016 where he pled nolo and an FTA. From 2020. He also has 3 open cases, a theft by receiving and obstruction through APD. He was arrested on February of 2021 in that case. He has an open FTA, which is now a pretrial bench warrant. So I believe that will be holding him unless resolving these cases resolve that. That occurred April 2021. He also has an obstruction and criminal trespass from April 2021 that is open as well.
Okay, the obstruction from April 21, isn't that position 10? Or no, it's a different case?
April 28th.
Wouldn't that be the one? I'm just curious.
Possibly, because
That's the same date and charge. I'm assuming that that's the case we're resolving here today.
possibly, because we do have, even with his convictions, he has like multiple convictions in a year, so he could have violated multiple times in April. So it could be a different one. That case hasn't been bound over, so I wasn't able to really dig
All
in.
right. That makes sense. All right, I'm gonna ask you some questions, Mr. Fowler, to make sure you are voluntarily taking the plea today. Can you raise your right hand for me? Thank you. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah.
I'm sorry?
Yes, sir.
Okay,
Yes,
all right.
yes,
You put your hand down. All right, are you under the influence of any drugs or alcohol at this time? I need you to say yes or no.
no.
All right, are you satisfied with your attorney's representation? You're not?
I mean, yes,
You're satisfied with Mr. Bartel's representation today?
yes, sir.
All right. That's interesting. All right, and you understand that there are 4 charges pending, 4 different cases that you have at this time, and you're not gonna have any further court dates regarding these cases? You understand that?
Yes, yes, sir.
And you're giving up your right to have a full trial regarding these cases.
Yes, sir.
All right.
Ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yeah.
You are?
Yes, yeah. I'm good, I'm got it.
All right. You understand this entire proceeding and what's happening today?
Yeah,
All right. And do you understand the requirements of your sentence?
huh?
Do you understand the requirements of the sentence that you can't go back to any of these places, that Dunkin' Donuts or that racetrack? Do you understand that?
Yes, ma'am. So,
They're right next to each other. They're.
so I'm getting credit for time serving, I get to leave today?
Well, I'm asking you some questions to see if that's what we're gonna do. Okay, so do you understand you can't go back to that place?
Mm-hmm.
I didn't say yes.
Yes,
And so you understand no going back to the Dunkin' Donuts, no going back to the racetrack. You understand that?
mm-hmm.
All right. And you understand that the state would have had a full trial and had been forced to present witnesses and evidence to prove these charges against you, and you're giving up that right?
Mm-hmm.
And you understand that you're taking a plea of guilty to these charges today. You understand that?
Yes.
And you understand that if you have any other open cases, taking a guilty plea may affect those cases?
I think so.
Do you understand that? It's not, I think so.
Yes, sir, I mean, yes, ma'am, yes.
You understand that? All right. As to the charges, I previously listed Mr. Fowler. How do you plead?
Guilty.
All right, I accept your guilty plea at this time. Is there anything further from the state or the defense?
Oh, just to stay away, obviously I didn't say it, but.
Well, I mean, I feel like I asked him quite a few times if he understood he couldn't go back there. Seems like we got that, yes, so.
Okay.
Anything further from anybody else? Don't go back to those locations. I have said it several times, and Ms. King has asked that we reemphasize that. Do you understand that, Mr. Fowler?
No.
Yes, was that a yes?
Yes, sir.
All right, thank you. All right. That will conclude your case. Best of luck to you, Mr. Fowler.
All right, thank you, Your Honor.
All right, Mr. Fowler, absolutely.
She said you can't go back to that. And then this you sent me, late.
Next, position one, Mr. Alexander Ryan.
All right, Mr. Alexander, your case is 22 CR 0075848. In this case, you're charged with criminal trespass, willful obstruction, theft by taking, and possession and use of a drug-related object, each with the offense date, of November the 3rd of 2022. Do you understand your rights?
Yes.
You do? I need you to say yes. Thank you.
Your Honor, Mr. Alexander advised me that he has a sore throat. He has some difficulty making his language known.
All right, so if this is a negotiated plea, Mr. Bartels?
Yes, Your Honor, it is.
All right, Ms. King, if you give us the state's offer as well as very briefly, the facts and basis supporting that offer.
The state's offer is 12 months to serve 28 days, credit for time served 14 days with the balance probated, a ADET, theft class, no further contact, and stay away. This offense occurred November 3rd of this year. Officers were dispatched to a person screaming. Upon arrival, they saw the defendant who matched the description given by dispatch. They told him to, put his hands up. He kept digging into his book bag. Ultimately, when his hand came out, crack came out, Your Honor. And then it was also found that he had been previously criminal trespassed from this location. On his possession, he had a cell phone belonging to Randy Parker, and he refused to return the phone to Mr. Randy Parker. And then when they tried to detain him, he snatched his arm away in an aggressive manner. The defendant has a criminal trespass conviction from 2019, manufacturer, distribution, or sale of marijuana conviction from 2018, as well as possession of cocaine conviction from 2015. He has an open aggravated assault, possession of firearm or knife during commission of a felony and terroristic threats, 20 CP 192313. He's out on a 20,000 signature bond on that case, which he violated with this offense. He also has an open probation violation from Hateville PD from 2021 that is still open. The state feels the ADT is necessary due to him having multiple convictions with drugs and even have drugs on him during this arrest.
All right, and Ms. King, if you would give us the name of the alleged victim with whom he is to have no further contact.
It is Randy Parker, both traditional spelling, and the location for the stay-away is the Red Snapper at 501 North Central Avenue in Hateville.
All right. All right. Mr. Bartels, was that your understanding of the offer, and do you stipulate to the factual basis, ID, and venue in this case?
That is, Your Honor, we do stipulate to that. And Mr. Alexander does understand he cannot go back to this location. He does disagree with some of the allegations, but I've advised him of his options. And if the court wants to hear this, I guess it could be an Alfred plea, because he does believe it's in his best interest to accept the state's offer. But it is a negotiated.
All right. Ms. Alexander, I'm going to ask you some questions. I understand that you are having some difficulty with your throat, so please do your best. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yeah.
All right. You can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
And you understand that if you take a plea today, you're not going to have any further court dates regarding these charges?
Yes.
And you understand that you're giving up your right to have the state prove the charge against you beyond a reasonable doubt? And you understand you cannot return to the Red Snapper location on North Central in Hapeville?
Yes.
And you also understand that the time that you serve in the Fulton County Jail will close your case, but you still will have to complete a theft class and undergo some evaluations, in addition to having no contact with Mr. Parker. Do you understand all of those conditions, Mr. Alexander?
Yes.
All right, as to the charges I previously listed, Mr. Alexander, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything further from the state of the defense?
Well, Your Honor, given his, that he'll have to be paying for the ADET and the theft class, we would ask the court to consider waiving the first 3 months of the probation fee to allow him to work on that.
All right, the first 3 months will be so waived.
Thank you, Judge.
All right. Best of luck to you, Mr. Alexander. That concludes your case.
Thank you, Judge.
Position 2, Bonnie.
All right, good morning, Mr. Bonnie. Your case is 22 CR 007586E. In this case, you're charged with criminal trespass with the offense date of November the 4th. Do you understand your rights?
Yes.
All right, the announcement I have is TBA. So what's your announcement, Mr. Bartels?
Well, Your Honor, despite my efforts, I was not able to meet with Mr. Bonnie yesterday, so I would need to speak with him before making an announcement.
Okay, we can put him off to the side.
All right, we'll come back to that position so you can speak to him. Is there another position we could go to?
What about for 19, Miller?
19. Yes, that will be a plea.
Mr. Position 19, Mr. Miller.
Let me go get the paperwork from Mr. Miller.
All right, Mr. Miller, your case number is 22 CR 007529A. In this case, you're charged with criminal trespass with an offense date of November the 2nd of 2022. Do you understand your rights today?
Yes, ma'am.
All right, thank you. And the announcement I have is that this is a negotiated plea. Ms. Backus, will you please give us the state's offer, any relevant history, and very briefly, any facts supporting that offer?
Yes, Your Honor. The history, he has 16 cycles. Most recently, 2019, it looks like he was convicted of 2 probation violations. 2019 criminal trespass, he pled nolo. 2018 disorderly conduct conviction. 2016 4 counts of felony theft by taking, where he received 10 years probation, so he would still be on probation. He also has 2 other 2019 criminal trespasses, a 2018 criminal trespass, a 2018 misdemeanor marijuana, 2018 FTAs, a couple more probation violations, 2017 robbery and FTA, those are arrests, Your Honor. The factual basis is that on November 2nd, an officer was dispatched to 75 Gammon Avenue to assist another unit in reference to a trespass call. Upon arrival, the defendant was detained by the other officer, and the owner of the home, Mr. Hen, advised that when he returned, he noticed an unknown Black male standing around in the home. He told the Actually, let me take that back on, because I don't want to, I want to make sure that the record is correct. It says standing around. It is my assumption that it was in the home. It says he told the male to stop, and he did stop. Then he flagged down the first officer. And officer 2 recognized, when he arrived, he recognized the defendant because he had been previously trespassed from other local businesses in the neighborhood. And when the officer asked the defendant why he was inside of Mr. Hen's home, he said he needed somewhere to live. And he had entered the home through the front door because it was unlocked. And that's when he was placed into custody. The state's recommendation on this is 12 months, 16 days to serve, credit for time served, 16 days, balance suspended, and stay away from that incident location, which again is 75 Gammon Avenue. That's GAMMON.
And I'm sorry, I did not get Mr. Hen's first name. I'm assuming the state might be requesting to stay away from him, or is that not correct?
I think.
No contact with him.
I didn't request it, Your Honor, but let me pull up the report right now so that I can give you the first name.
Yeah, I don't know that we actually know his whereabouts. So I think that.
Okay, so the stay away should be sufficient.
Right.
All right.
His name is
Mr.
Jonathan Hen, Your Honor, just so you have it.
For my own edification. Thank you.
Mhm.
All right, Mr. Miller, I'm gonna ask you some questions to make sure that this is a voluntary plea. Will you please raise your right hand? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yeah, ma'am.
All right, thank you. You can put your hands down. All right, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yeah, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And I'm sorry, I did start asking questions. Mr. Bartell, did you stipulate to the factual basis, ID, and venue? And was that your understanding of the offer?
We do, Your Honor.
All right, we'll continue with Mr. Miller's line of questioning. Mr. Miller, you understand that if you take a plea today, you're not gonna have any further opportunity to have the state prove these charges against you beyond a reasonable doubt at a court date? In essence, you're not gonna have any other court dates about this. You understand that?
Yeah, ma'am.
And you're prepared to give up your right to have a court date?
Yeah, ma'am.
All right, and now that your attorney's explained, you understand that there's not gonna be any other dates about this. This is gonna be the end of this case and you're gonna take a guilty plea?
Yeah,
You
ma'am.
understand? All right,
Yeah.
and if you have any other open cases, taking a guilty plea may affect that. You understand that?
Yeah.
All right, as to the, and you understand that you also cannot go back to that home on Gammon Avenue. You understand that, Mr. Miller?
Yeah, ma'am.
Otherwise, the time you served in the Fulton County Jail should close your case. All right. As to the charge, Mr. Miller, of criminal trespass, how do you plead?
Yes,
I'm sorry?
yes,
As to the charge of criminal trespass, how do you plead, Mr. Miller?
guilty.
All right, I accept your guilty plea. Is there anything further from either party regarding this particular case?
No, Your Honor, just, I didn't know if you added the no further contact or not.
I didn't. I feel that the stay
Okay.
away is
Okay.
sufficient.
Sounds good.
Nothing
Thank
further
you.
from defense. Thank you.
All right, best of luck to you, Mr. Miller. That's the end of your case. Don't go back to that location, okay?
Yes, ma'am.
All right, thank you, Your Honor.
All right, thank you.
Position 1 on the add-on, Mr. Jones.
All right, Mr. Jones, your case is 22 CR 007455Y, in which you're charged with criminal trespass with the offense date of October the 29th of 2022. Do you understand your rights?
Yes, ma'am.
All right, the announcement that I have for add-on 1 is that this is a negotiated plea. Is that still correct, Mr. Bartels? Oh, Mr. Bartels.
Yes, Your Honor. Thank you.
All right, Ms. King, if you would give us the state's offer as well as the factual basis.
I believe the offer was 12 months to serve, 60 days, credit for time served, 18 days with the balance probated, no further contact, and a stay away. Is that correct?
There's no announcement on my papers.
I have in my notes 40 days. He's been in for 20 days right now. Given the allegations, we were going to ask for basically time served for 40 days, credit for time served 20 days.
And the state, oh, I'm sorry, go ahead. You want me to, okay, well, the state would object to that due to the defendant having battery family violence conviction from 2021. He also has a criminal.
Hold on 1 second, Ms. King. I'm
Mhm.
not sure that I got the offer, so it's no longer negotiated? Is that correct?
If the state could state what the offer is, I could answer that.
It will be 12 months to serve, 60 days, credit for time served, 20 days with the balance probated, no further contact, and a stay away. So the state is asking for time.
How much additional time has the state? I'm always gonna ask you that. I'm never.
It'll be 20 days, Your Honor, because
You're asking for an additional 20 days, and
That
Mr.
is correct.
Bartels is asking for time served. All right, so let's go through the facts here. It'll be a non-negotiated plea.
yes, Your Honor. This offense occurred on October 29th of 2022. Officers responded to 5 Lamar Avenue due to a criminal trespass call. When they arrived on scene, they first noticed the defendant standing in the front yard having a verbal dispute with one of the victims in this case, Christopher Favors. And the dispute was regarding his girlfriend, Talia Hightower. At that point, the officer went to detain Mr. Jones. And this officer was actually the one that gave him the criminal trespass last time.
Ms. King, please hold for one short moment.
Sure.
Mr. Bartels, before we proceed, I'm hearing that originally Mr. Jones had a conflict attorney and that the public defender's office may have been conflicted out. Is that no longer correct? Is Ms. McLeod on the line? We may not be able to do this position if the public defender's office.
I did not see anything in Odyssey about him being represented, but if that is a possibility, perhaps the case could be.
Right, I think there's a possibility that the public defender's office may have been conflicted. Let's check Odyssey.
Your Honor, is this position add-on 1?
Yes,
I believe it was reset from Tuesday for that exact purpose, if my memory serves me correctly.
that's what Ms. Grace is telling me. So we cannot address this case today unless Ms. McLeod is on the line. Is Ms. McLeod on the line?
She's not, but Attorney Watson is on the line. I'm not sure if she's interested in picking up
Another conflict case. Ms. Watson, Cafe, I know that you are not assigned to this particular conflict case, but there
Yes,
is
Your
a
Honor.
gentleman on the line where we believe the public defender's office may be conflicted out. I'm not sure if you're able and willing to assist him, but he's already been reset one time apparently for this particular reason. I would reset him again. But it might be good if were able to speak to him because it does not appear that I'm sorry. It's not.
I'm happy to do that, Your Honor.
It's not what, Mr. Okay, yeah, so what we'll do is, if perhaps you can make contact with Mr. Jones, Ms. Watson Cafe, and we will reset his case unfortunately again to Tuesday.
Okay.
Will that give you?
I mean, I'll call
time?
courtroom too, because if there's already a plea and he's interested, then,
Oh, perhaps we could take it today. Okay, if that
Yes,
gives
Your
you enough time. So let's come back to Mr. Jones's position and give Ms. Watson Cafe an opportunity to speak with him.
All right, thank you, Ms. Watson.
Thank you for that, Ms. Grace, as
Ms.
well.
Watson, do you have the?
and I'm sorry, what is, his last name is Jones, I'm sorry.
Jones, Mondravius Jones, and he's position, if you have the calendar, he's position 1.
And then
Or
Ms.
the
King, if you
add-on.
can just put the recommendation in the chat to Ms. Watson.
Will do.
Thank you.
Thank you.
All right, thank you. Thank you, Mr. Walker, as always, for those dynamic solutions. All right, who do we have next?
Can we do position 30?
And at some point, I do see that there's a private attorney on the line. I believe I don't know if we're in a place where we could take his case, but maybe we could try to get to that case as well, but we'll go to position 30. Caprice Weaver. All right, are you Caprice Weaver?
Yes, ma'am. Weaver is ready for a negotiated plea.
All right, good morning, Mr. McLean, good to see you. All right, Mr. Weaver, the case is 22 CR 007567F. In this case, you're charged with committing certain prohibited acts in a rail or bus station, possession of marijuana less than 1 ounce, and criminal trespass with the offense date of November the 3rd. I don't believe you've heard your rights, so I'm going to tell you them at this time. You have a right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today, and Mr. McLean is present on the Zoom conference and able to assist you. This particular proceeding is being broadcast over the internet as a live stream, and it's also being recorded. That means any member of the public can log on and watch this. Do you understand all of that?
Yes, Your Honor.
All right, thank you. Ms. Campbell, if you will give us the factual basis and the offer, as well as any relevant or pertinent history.
Yes, Your Honor. The facts are that I'm sorry, first let me put the offer on the record. The offer is 12 months to serve 20 days, credit for the time served 15 days, the balance to be probated, and that he is to comply with all active MARTA suspensions. And that's going to be on all the counts, all 3 counts. And the facts are that officers observed this defendant possessing / using a marijuana blunt while he was in the vicinity of a MARTA station. And this defendant had previously been banned from that MARTA station. And when they observed him using the marijuana blunt, he was inside of the station sitting down on a bench.
All right. And any relevant history, Ms. Campbell?
Yes, he does have 5 cycles. He has a 2018 conviction for possession of a firearm during the commission of a felony. He also has a 2019 FTA conviction. It looks like he had a arrest in 2021 for disorderly conduct and obstruction that was dismissed. And it looks like he had another 22 arrests for criminal trespass, terroristic threats, and obstruction in August of this year. And it looks like that also occurred at a MARTA station, but not this MARTA station.
All right, thank you. Mr. McLean, was that your understanding of the offer, and do you stipulate to the factual basis, ID, and venue?
Your Honor, it is our understanding of the terms, and we do stipulate to those 3 items.
All right, thank you. At this time, please raise your right hand. Do you swear and affirm that the testimony you give today for the limited purpose of taking a plea will be the truth to the best of your knowledge under the penalty of perjury?
I do.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Did anyone promise you anything in exchange for taking a plea today?
No, Your Honor.
Did anyone force you to take a plea today?
No, Your Honor.
And do you understand that by taking a plea, you'll have no further court dates regarding this, and the state no longer has to prove these charges against you beyond a reasonable doubt?
Yes. Yes,
And
Your
you're
Honor.
prepared to give up those rights?
Yes, Your Honor.
And you understand that if you're on probation or you have any other open cases, taking a guilty plea may affect those?
Yes, Your Honor.
All right, as to the charges I previously listed, Mr. Weaver, how do you plead?
Guilty.
I accept your guilty plea. As part of this sentence, you're required to comply with any active minor suspensions, and I don't believe that you should have any additional time to serve. Is that correct, Mr. McLean or Ms. Campbell?
That is correct.
All right, so just don't go back to those MARTA stations, okay?
Yes, yes, Your Honor.
All right, I believe that concludes this case unless there's anything further.
Your Honor,
No, Your Honor.
since he does have balance probated and will be perhaps, not for sure, but perhaps paying out of pocket for the ADE, the alcohol and drug evaluation, could the court forgive a few months worth of probation fee?
I wanted to clarify that point. Ms. Campbell, you didn't necessarily read that even though that appears in my calendar. Are you still asking that he undergo the ADET? You're muted.
Yes, Your Honor. I apologize. This is a reset from Tuesday, so I had put that on the Tuesday calendar and just didn't. Yes, I'm still asking for the drug evaluation and treatment.
All right, so you also understand, Mr. Weaver, that you need to complete some evaluation for alcohol and drugs. You understand that?
Yes, Your Honor.
All right, since he has to do that, I will waive 3 months of probation fees.
Your Honor, could this become non-reporting at some point?
Let me see, what are his charges? I don't have an objection to the non-reporting. Let me see if the state has any objections. I'm inclined to allow it to go non-reporting.
No objection.
All right, once he's completed the evaluations, they can go non-reporting.
Thank you so much.
All right.
All right. Okay.
Best of luck to you, Mr. Weaver.
Position 32, Winstead.
All right, good afternoon, Mr. Winstead. I mean, it's not afternoon, it's still morning. Good morning, Mr. Winstead. Your case is 22 CR 007744Y. In this case, you're charged with loitering and practicing with the offense date of November the 3rd of 2022. You understand your rights?
Yes, Your Honor.
All right, thank you. The announcement that I have is that this is going to be arraigned and we're going to have a bond hearing. Is that still correct?
Yes, Your Honor.
All right, so I'm gonna arraign this case at this time. Mr. Winstead, in this case that I have just read to you, you are charged with 1 count of loitering and prowling, which has been formally accused by the Solicitor General of Fulton County, Georgia. Mr. McLean, do you waive a formal reading of the accusation?
We have a copy. We waived the reading of it.
All right, thank you. At this time, the case will be set for trial, and the trial will be scheduled by the state court judge to whom this case is actually assigned. Mr. Winstead, please make sure that your address and phone number are current with the court, and as well that you give your attorney a current updated address and phone number as well. At this trial, you will have the right to an attorney just as you've had today, and the state will bear the burden to prove those charges against you beyond a reasonable doubt. If they do get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Winstead, how do you plead?
Not guilty, Your Honor.
All right, I accept your not guilty plea, and now we'll hear bond arguments. Ms. Campbell, if you give me the state's position on bond and the factual basis supporting the state's position.
Yes, Your Honor. The facts as alleged are that on the date of November 3rd, 2022, at approximately 9:21 a.m., officers were dispatched to the location of 1276 Upper Hembry Road, which is the Atlanta Grill Company. They did receive a call for a suspicious vehicle that was parked at that location while the business was closed. The business owner saw the vehicle drive past his front door and then back into a spot. The business owner also reported that both occupants of the vehicle had on masks and that his business had not yet opened for the day. So he did think that they may rob him. Upon arrival, officers observed the defendant, who they later identified as Keith Winstead, seated in the driver's seat. He was wearing a black ski mask when the officers observed him. And as the officers approached the vehicle, they did see the defendant remove the ski mask from his face. They also saw the defendant sitting in the driver's seat with a hatchet in his lap when they approached the vehicle. And upon further investigation, they also found a machete positioned in the driver's side door next to where the defendant was seated. When they asked the defendant why he was present at that location, the defendant stated that he was waiting for somebody to bring him gas. However, when the officers contacted the individual that the defendant claimed was bringing him gas, the individual said that that was not true. And they also contacted that individual because he was the owner of the vehicle that the defendant was driving. And he reported that the defendant was supposed to have returned his vehicle weeks ago and that he had been unable to get in contact with the defendant to get his vehicle back. Search incident to arrest revealed $1,980 in fake United States currency within the defendant's possession. So those are the facts. This was originally charged as a felony. However, the felony charge was dismissed, which left us with the loitering and prowling. And currently, this defendant has a $3,500 good bond. The state is asking that that bond remain the same. The state does believe that this defendant is a danger to the community. The facts of this case alone are very concerning to the state. The state believes that but for police intervention, the defendant and his co-defendant were likely to have committed a robbery. That's why the state alleges they were there with ski masks and machetes and knives on the property while the property was still closed. The state will also like to note that at the time of this incident, the defendant had just been placed on probation for felony theft by taking. The conviction date of that is March of 2022. He was given 5 years probation for that, and that was in Henry County. So the state does also believe that he's a risk of reoffending in light of the fact that he has that recent conviction for theft by taking. When he allegedly committed this act, he was on probation for that. And I would also like to note his other criminal history, which is that he has a 2013 conviction for burglary out of Spalding County, a 2013 conviction for robbery out of Henry County. He got 10 years probation in that case. So arguably he's still on probation in that robbery case from 2013 because we're not in 2023 yet. We also have a 2017 conviction for simple battery family violence. We also have a 2018 conviction for possession of a firearm by a convicted felon. He also had a probation violation from that case where he served 2 years from that felony case. We also have that he was arrested in 2021 for conspiracy to commit a felony, and that was no pros in March of this year. So the state's concerned that he's a risk of reoffending, he's a dangerous community, and he's a serial convicted felon that was in a parking lot of a closed business with a machete and a knife and a ski mask. So the state is extremely concerned about this defendant receiving anything other than a surety bond. So the state would ask that $3,500 bond remain the same.
And I'm sorry, what were the special conditions that are already attached to that bond? I'm sure it's to stay away from the address on Upper Henry. Were there other conditions?
I do have that he's to have stay away.
I'm assuming, I'm sure there's a stay away, but I wanted to know if there were other conditions already attached to that bond.
That's all that I have for the bond conditions, Your Honor.
Let's stay away. All right, Mr. McLean.
Your Honor, I can't state that there's a true legal change of condition, but the family tells me about his dad. And between his dad and his granddad, they're attempting and trying to make the bond. it would be helpful to the family. The rehab has been scheduled. It's going to be in-house, inpatient, whatever it's called, for a drug situation. And if they can make that bond at a lower level, such as $1,000 or $1,500, or if the court could even consider a signature bond, that would enable him to go on into that facility.
All right, thank you. At this time, Mr. Winstead's bond will remain set at 3,500 surety, and the conditions that he must stay away from that location on Upper Henry. All right, is there anything further from either party?
Thank
No,
you,
Your
Your
Honor.
Honor.
All right, best of luck to you, sir. Who do we have next?
Position number 15, Jacobs.
All right, good morning, Mr. Jacobs. Your case is 17 CR 0024137G. In this case, you're charged with reckless driving, basic rules going too fast for the conditions, and driving without a valid license, each with the offense date of March the 21st of 2017. Do you understand? Oh, you haven't heard your rights. You have a right to remain silent. Anything you say regarding the facts of this case can and will be used against you. You have a right to an attorney here today. And this proceeding is being broadcast over the internet. That means that any member of the public could log on and watch this. Do you understand that?
Yes, ma'am.
All right, thank you. I understand that there was some confusion. Is this Mr. Bartell's case or is this yours, Mr. McLean?
What is the position number, please?
15, I have, this is Mr. Bartell's. Apparently the wrong person was brought before.
Oh,
Is
this is the Jacobs case?
Yes.
The one in my memo that I referred to as an odd situation. Your Honor, these are brothers and their criminal histories are, I'm not saying they're long, however short they are, their criminal histories have apparently gotten completely mixed up. There's an Andrew and there's an Antonio, and the person we've been bringing to court so far was the wrong person. And by coincidence, the booking number I named in the announcements is the correct person. So if the correct person is here, he is Antonio Jacobs, and he tells me, he says, you know, I believe I remember that from 2017, from March, and I paid fines on that. And I said, well, if you did pay fines at city court on a traffic matter from March of 2017, then you should plead overflow acquit. And that would be, it would be necessary for somebody to go down to city court, find evidence that you paid fines on it, and that it took care of the case. Otherwise,
so the announcement, Mr. McLean, then is that this is going to be an arraignment, and he's not. We're taking a not guilty on this.
Correct, because we don't have the time. You know, we don't have the wherewithal right now to prove that fines were.
Okay.
I'm sorry, who is this speaking? Is this Mr. McLean?
Mr. McLean.
Was this from City of Atlanta?
He says that he took care of it in the city of Atlanta by paying.
So you know that's public record and they have a website. So did you not pull it?
Well, the point is, we're not gonna do it today.
Yeah, you can't do it today.
We're not gonna do it today. So let's clarify this first, though. Are you Antonio Jacobs, not Andrew Jacobs, correct?
I'm Andrew Jacobs.
You're Andrew, so we have the wrong defendant again?
Yeah, yes, ma'am.
So
okay, so we can't even do this. The wrong, okay, we don't want this to keep happening.
Right.
Is someone there at the jail that could actually get us his Mr. Antonio Jacobs, not Andrew?
I'm locked up on Antonio Jacobs.
He said, but he's locked up under Antonio Jacobs. So in this system, when I pulled up Antonio Jacobs, this is the person that I got.
Right, and what we need is to pull up the booking.
I am very confused. So this gentleman who's here before me is not here for this. He didn't. These are not his charges, Mr. McLean, or these are his charges. He just has the wrong name.
He says these are not his charges. He says that at the time he was somewhere else. So the brother is booking number that I named in the announcements, and if we can bring that person into the courtroom, he will stay.
Now, I have to search where the person is because I don't know. I didn't know anything about him. Andrew.
So are both brothers in custody?
That's the understanding I have, Ms. Backus. Is that correct, Mr. McLean?
Yes, 2216-494 is who we need.
We have the wrong gentleman, so we can't do position 15. We
Correct.
need, his brother, Mr. Antonio. I guess they booked them both in incorrectly. So my question then is, does the jail have two Antonio Jacobs? I mean, I'm sorry, yes, do they have two, or do they have one? Are the names inverted? I guess that would be my question. Like, if we go get Andrew Jacobs, will we get the correct person?
You will.
Can I have that booking number again?
2216494.
Repeat
I'm
it,
gonna look him up. I'm not sure. Let me look him up.
Okay, so we've got the wrong person. We'll clarify that point later. All right.
So it is an odd situation, but I think we
So
can,
it is, it's my hope that we can at least arraign that case today
correct.
and have him brought to court. All right, so we'll move to another position.
Position 1, add-on, Mr. Jones.
All right, we're going back to Mr. Jones. I've already read Mr. Jones his rights. We've gone through some plea explanations. Ms. Watson Cafe, does he wish to take the plea? What is your announcement? Let's do that.
Yes, Your Honor, he wants to take the plea, but he's okay with all of the conditions except for the additional incarceration time, which my understanding would be an additional 10 days on a 2-for-1.
That's correct.
And if I decide, well, let me hear your presentation, Ms. Watson Cafe. I believe I already heard from Ms. King. He was, please refresh me, actually, Ms. King. All I have is that he was at 5 Lamar Avenue. And what were the allegations?
When officers arrived, he was standing in the yard, yelling and arguing with one of the victims, Christopher Favors, in regard Mr. Favors' girlfriend, Talia Hightower. And the officer was the one that gave him the criminal trespass. So he's like, what are you doing here? And he says, I'm trying to fix an issue with Miss Hightower. At that point, he was arrested and taken into custody. We have been in contact with this victim. She states that he keeps coming over to see her to the house. And he was arrested last month, 22 CR 006043Y for criminal trespassing at the same location. He was actually convicted for that, and he's on probation currently for it. And there's a stay away probation condition, which he violated with this offense. Your Honor, the victim says she wants him to stay away from the residence. She wants him to stay away from her. Just go away, like just stop coming around. The state feels that the extra time is appropriate due to just a month ago, he was convicted of criminal trespassing at the same location, got out and came right back, which shows he has no regard for the state, for the laws of Georgia, for the court's orders, or for her safety and her wishes. For that reason, the state feels that the extra time is more than appropriate. No, in addition to the battery family violence conviction from 2021.
All right, and if he were, I'm sorry, and to give me the offer again, I have 20 days credit. I'm sorry, give me the whole thing, Ms. King, so I can rewrite it.
It is 12 months to serve 60 days, credit for time served 20 days with the balance probated, no further contact with Christopher Favors and Talia Hightower, and to stay away from 5 Lamar Avenue.
All right.
So that would be 10 extra days.
Okay, 10 extra days. All right, Ms. Watson Cafe.
Yes, Your Honor, thank you. We would be asking again for this to be time served, for him to be able to be released on probation, immediately. I have spoken to Mr. Jones. I have expressed to him the importance of staying away from the location. He is eager to, I guess, take the class and again, get back to his family and everything. He currently is employed through the Vine City Association, where he works with the homeless and passing out food. Again, it's his primary source of income. He does not have any children or any other reason to be back at the location. I have also expressed that even if she were to reach out to him, seems to may have been an issue in the past, that he cannot respond to that. He's a lifelong resident of Georgia. Your Honor, this is a criminal trespass case. I understand that he's had some issues in the past with this, but again, he has assured me that he will be staying away from the alleged or the victims in this case, and also the location. So we would ask, I don't think that it does anything for the state to pay for an additional, for the county to be paying for an additional 10 days for him to stay in custody. I don't see the purpose in that. So for those reasons, Your Honor, we would ask that he be allowed to do time served, and again, the rest of the conditions, special conditions, he does not have an issue with.
The state didn't request any classes, did you, Ms. King?
I did not.
Oh,
But
my apologies. I wrote that. I'm sorry, Your Honor. I was sorry.
But
Ignore
the
that.
purpose is that when he pled guilty last time, he was released, time served with the condition of stay away. He violated that a month later, which shows he shows no regard. He doesn't care. So for that reason, we feel that time is appropriate in this instance.
Ms.
Your Honor, I would
Watson
ask-
Cafe, if I decide to accept the state's recommendation, does he still want to take the plea today, or would he rather enter a not guilty plea?
I believe he still wants to move forward, Your Honor. That was my understanding, but that was my understanding that he would still want to move forward. But
And
I would
I know
say that
you had a response. Please give me your response, Ms. Watson
that the
Cafe.
20 days I feel is sufficient. He's been in custody. This is a criminal trespass matter. It sounds like it was a verbal argument. And again, I've explained to him the importance of staying away, the importance of no further contact with the victims in this case, and with the understanding that even if they reach out to him, that he cannot do that. I think that there's sufficient, I think that the stay away is sufficient. He understands that he'll end up right back here. He has over 10 months that he has to stay away on this case. So I would say that with that kind of hanging over his head, that would be enough. He doesn't need to serve an additional 10 days on this charge, Your Honor.
How much time, my throat as well. Excuse me. How much time did he serve on the last time? Is anyone aware? I'm just curious.
I can find it right quick, Your Honor. Oh, well, Odyssey. Let me see.
Oh yeah, Odyssey is not your friend this week. Let me see if I can see myself. I'm just curious if he served.
Deterrent was the word I was looking for, Your Honor.
I got you.
Violation.
I would
enough of a
like to
deterrent.
know. I just want to know if he had similar time last time.
Yes, Your Honor.
I'm hoping Miss King can find it because Odyssey won't even let me in.
Yeah,
I'm not sure, but maybe Pretrial can help us.
he served 24 days last time.
He served 24 days last time.
He went into custody September 7th, was released on September 30th.
All right.
And came right out and did it again, Your Honor. So
All right. If I'm Ms. Watson Cafe, I'm going to accept the state's recommendation. Does your client wish to move forward?
Mr. Jones, you understand that? He says yes. He gave me the thumbs up, Your Honor.
All right, Mr. Jones, I'm going to ask you some questions. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the, I'm sorry, Ms. Watson Cafe, do you stipulate to the factual basis, ID, and venue in this case?
Yes, Your Honor.
Thank you. All right, are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Has anyone forced you to take a plea today?
No, ma'am.
Did anyone coerce you into taking a plea today?
No, ma'am.
And you understand by taking a plea that you're not going to have any further court dates regarding this particular case?
Yes, ma'am.
And you understand the requirements that upon your release, you absolutely cannot go back to 5 Lamar Avenue, and you can have no contact with the alleged victims, last name Favor or Hightower. You understand that?
Yes, ma'am.
All right. As to the charge of criminal trespass, Mr. Jones, how do you plead?
Yes.
I accept your guilty plea. Is there anything further from the state or the defense?
nothing from the
Nothing
state.
from the defense, Your Honor.
All right, best of luck to you, Mr. Jones.
Your Honor, if the court could just please indulge, can we please go back to position 15? I have some clarification. I don't know if Mr. McLean is
Okay.
available. for another.
Yes, we can go back. Is that gentleman? I guess whoever was at 4 North who's looking for the other person.
Cause
might
that's
be-
I just, correct me if I'm wrong, that was Antonio Jacobs that was in front of us, correct?
No, he was saying he was Andrew Jacobs.
Oh, I
Right.
had it the other way around.
We
I
have,
had that his name was
We,
Antonio.
we need Antonio, Mr. Walker, and he's
Okay.
booked in as Antonio, but he's saying that he is in fact
Okay, well, now-
Antonio's brother. He is Andrew.
Okay, Mr. McLean is on here, so I did pull up the City of Atlanta case. He pled not, whatever brother it was.
whoever.
He pled not guilty. It was bound over to our office, April 24th of 2017. So the case was not disposed of, and this is an open case, and I would be glad to share my screen if the court would like to see it.
No,
Again, it's
we
public
believe you.
record.
The real issue here is the wrong person was before us. So
Right, because it sounds like they're lying about their identities, but nonetheless.
they might be, but you know, what can we do?
Because nonetheless, the case is still open. I just wanted to put that point on the record.
Right,
We'll find
I
this
just cannot in good faith arraign the wrong person. We have to know that
Correct.
the person is booked in.
Oh, I definitely agree. I just wanted the court to know that this case has not been resolved and it was bound over to our office.
That is extremely useful information. And when we find the right person, now we've looked at the booking number that I stated, and that is not coming up with the right person. So ultimately, we're gonna.
I'll leave that to the jail. That was my only announcement. Thank you.
All right, thank you. Hopefully the right person can be brought today and at least we can arraign the case.
I think probably that's not gonna happen, Your Honor. We're just gonna have to talk to the family and find out.
Well, what I'm trying to avoid is that same situation happening over and over again, where they keep bringing us a person who, you know, was alleged to not be Antonio. I forget the last name, but we'll move forward.
Your Honor?
Even when you run, Andrew, it comes up the same person. So either name you run through Odyssey, it comes up the same person.
And that is correct. And also on the jail screen, it has both names, and the mugshot is for the person that was before, Your Honor, in the chair.
And that's why I was trying to relate the lie that he said that the case was already resolved to maybe he's also lying about who he is. But I mean.
But if there's another booking number and a whole other person, I don't know.
But I think Ms. King just said she matched the.
There's not
booking.
another booking number. It comes up, whether you run it Andrew or Antonio, it comes up the same person in Odyssey.
So as the state just stated, we just compared.
Okay, so
the
let's
booking
drag
photo.
that gentleman back then at some point.
So I mean, if he wants to keep on playing about a fine and stay in jail, that's his prerogative. That's his prerogative. But to be clear, I think it was a $300 fine that the state was asking for. So I'll let him do whatever his pleasure is.
That's an interesting, that's a new one. Very.
Oh, I've had defendants be.
No, I mean, but usually the jail is not able to, well, okay, let's forge ahead. We'll just forge ahead. All right, who do we have next?
33 Young.
Mr. Young, Your Honor, is not guilty. Bond is moot at this time. So we have a copy of the accusation. Can waive a formal reading of it.
All right, so we'll be arraigning this case. Are we also holding a bond hearing, Mr. McLean?
No, Your Honor, it's moot at this time.
All right.
For holding him.
We'll just arraign then. Thank you, Mr. Young. In case 22 CR 0075358, you're charged with 1 count of battery family violence, which has been formally accused by the Solicitor General of Fulton County. At this time, the case will be reset for trial, and the trial will be scheduled by the state court judge to whom the case is actually assigned. At the trial, you will have the right to an attorney, just as you've had today, and you do not bear the burden to prove the charges against you. The state, represented by the Solicitor General, will bear that burden. And if they do get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Young, how do you plead?
Not guilty.
I accept your not guilty plea at this time. If there's nothing further from either the state or the defense as it pertains to Mr. Young's case, his case will be so reset.
Thank you, Your Honor.
All right, and I believe that there's a victim on the line, Ms. Clouden, who was here for this particular case. Ms. Clouden, this defendant has pleaded not guilty and the case will be reset. We do not have any court dates, so feel free to drop off of this proceeding. All right. I believe that concludes this case. We can go to the next position.
Position 8, Fleming.
That's a negotiated plea.
All right, thank you, Mr. McLean. If I could just get to it. All right, good morning. You're Kenneth Fleming?
No, Miss Merle.
All right, and Mr. Fleming, in this case, 20 CR 005071F, you're charged with criminal trespass, family violence, 2 counts, with the offense date of December the 1st of 2018. You understand your rights?
No, yes, no.
All right. Let's see, Ms. King, if you will please give me any pertinent history, a brief summation of the facts as well as the state's offer.
So there are 2 open citation only cases, 19 CIT 000791 and 19 CIT 000792. I will extend the offer to globally resolve all 3 of these cases with the same offer of 12 months to serve, 48 days credit for time served, 24 days, an 8-week anger management course, no further contact, and a stay away.
And I'm sorry to break in, but if it's citation only, I believe that the defendant hasn't served any time on those cases.
Right.
So those will have to be time serve offers. Or am I incorrect?
Okay, so we'll need to, and I didn't quite, those numbers went so fast.
I'm sorry, 19 CIT 000791, and that charge is failure to obey a stop sign. And the next one is 19 CIT 000792. So Angie Walker, we're not able to.
If he hasn't served time on them, we could just do time served. And then as far as the sentence recommendation you just stated, it can go towards the case that he's currently being held on.
Got you. Okay.
Mr. McLean, is that something that your client wants to do? Does he want to accept time served guilty pleas for those 2 citations?
Those are on different dates than what we've discussed, I believe. So what is the date of the stop sign?
It was both of them are in 2019. And then the second one is failure to change name, address on driver's license. Let me see if I'm able to pull up the exact.
That sounds like it was on the same time as the stop sign.
That's what it appears. So yes.
And we just need to know the date of that, and I'll ask him if he remembers that and wants to discuss it.
One quick moment.
Are those 2 citations currently scheduled for a citations only calendar? Because those calendars have been coming up. It may not be appropriate to resolve that today. It may need to be resolved. Because I don't think we even have, we would have to find the citation for me to sign it and address it today. And I don't know that we have those.
Got you.
Rules. And I mean, Mr. Walker, if you have another dynamic solution.
No, I just say for defendants that I have to come back, but I definitely understand the courts.
Yeah, we would have had to have those pulled for us to even dismiss those or to deal with those today. So those citations will remain outstanding. Defendant will have to come back. And we are doing well with our citations only calendar. So, so Mr. Fleming, I'm making you aware there are 2 citations out there. You'll need to deal with those, address those with Mr. McLean, and show up for our citations only calendar to address those 2 citations that are before us today, okay? But we're not gonna deal with those at this time, all right?
Now, if I may ask a question, is 1950 Harbin Road an address which in today's matter, we're going to need to stay away from? Because if it's not, then he can get good mail at that address and keep up with those citations.
The state is requesting a stay away from that address.
Okay, if we could have just a moment.
Does he, we didn't get the facts yet, but yes, we'll do that as well.
Okay. The offense occurred on December 1st of 2018. Officers were dispatched to 1950 Harbin Road Southwest regarding to a door repeatedly getting banged on. When they arrived, they saw the defendant outside, and he had a butcher knife in his hand. He was threatening other tenants in the location. At that point, the officer went inside the home to clear it out and to make sure everything was okay. This is when they found the victims, Dennis Mumbum, Luke Peoples, and Timothy Fleming. They said that the defendant started acting irate, threw a living room television on the ground, put a large hole in the wall by slamming the front door into it. They also stated that the defendant made verbal threats towards them, especially towards the homeowner, Timothy Fleming, and he is the father of the defendant. He says that his son was upset because he didn't give him any money, which he intended to use for drugs, which led to the officers being called. The defendant has a 2017 disorderly conduct conviction. He has a theft by taking, simple assault, family violence conviction from 2013. So he has 23 cycles in total. The others are more remote. While they are some batteries, false imprisonment, felony drugs, they are removed, but it still concerns the state, especially since the father, who is one of the victims, is showing concern and he threatening and damaging property. For that reason, the state feels that there's no more time should be required, but we are asking for the 8-week anger management course, no further contact, and to stay away due to the safety of the victims. Their names are Dennis Mumbum, Dennis, last name Mbom. The next is Luke Peoples, Luke traditional spelling, last name Peeples. And the last is Timothy traditional spelling, Fleming, last name is the defendant.
All right. Mr. McLean, if he is to stay away from that address, which I'm inclined to do at this point, does he have another address where he could receive mail and reside?
Yes, Your Honor, he can use another address which he provided, and he can update his information. We'll put this, we have it on the contact sheet for probation.
All right. And so was that your understanding of the offer, Ms. McLean? And do you stipulate to factual basis, ID, and venue?
We do.
All right. Mr. Fleming, will you please raise your right hand? I'm going to place you under oath. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force or coerce you into taking a plea today?
No, ma'am.
Did anyone promise you anything?
No, ma'am.
Are you satisfied with your attorney's representation?
Speak up louder. I'm confused, but I have to say yes.
Wait, if you're confused, we can't take a plea today. You have to understand what's happening.
I'm satisfied.
Would you like to speak to your attorney further? Because the point of confusion causes the court some concerns. You have to knowingly, voluntarily, and fully understand this entire proceeding and what's happening. Mr. McLean, will you clarify any points of confusion, please, before we go any further?
The point of confusion, Your Honor, he says, as a matter of fact, that the Harbin Road address his dad no longer lives at, and that he should be able to return to that address because it's what, empty? It's empty at this time, or what?
That's my address. Those people there are renting rooms there. Me and my dad owns that property. We own the property.
Okay.
And so they don't even stay there anymore.
Okay, so what we'll do is we will allow him to return one time with a member of law enforcement to ascertain whether or not those people reside there. If they reside there, he cannot return to that location and must stay away. If they no longer live there, he can return to that address. So that's what the court's ruling will be. All right, does that satisfy that point of confusion? All right. Do you understand that by taking the plea today, you will not have any further court dates, Mr. Fleming?
Yes, ma'am.
And you will not have the opportunity to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand if you have any other open cases, taking a guilty plea may affect those?
Yes, ma'am.
All right. As to the charges of criminal trespass, family violence, Mr. Fleming, how do you plead?
Guilty.
I accept your guilty plea. The conditions will be as set. You should not have any additional time to serve at the Fulton County Jail. are gonna complete an 8-week anger management course. You're not gonna have any contact with the alleged victims in this case, and you're gonna stay away from that location if they reside there. We're gonna have a member of law enforcement escort you out there to ascertain whether they do not. Is there anything further from the state or the defense?
No, Your Honor.
Nothing from the state.
All right, best of luck to you, Mr. Fleming. That concludes your case.
Your Honor, sorry to do it, but can we go back to position 15? I just saw the message from Fort North.
Yes, that's gonna be our case of the day.
Oh,
All
this is
right.
this is gonna put it into it.
All right. All right, well, Fort North, if they could, we can go back to the case of Andrews.
Oh, I thought he was in front
They
of the
were
camera.
there. I don't know what happened.
It said-
This person is being interviewed by, Bartel right now. This is not Mr. Edwards, Adam client.
Oh, I thought we received a message that Mr. Jacobs was in front of the camera. Maybe I misinterpreted.
I couldn't find that guy. Every time I put the booking number in his he pops up.
So we think it's the same person. Is
So
what
the
we're
state's
assuming.
request is that he's brought back, he's arraigned, identity is an issue for trial. I've looked at his aliases, Andrew, Antonio, it's the same person. We've compared.
And the birth was
compared
the
the-
same too when I pulled it up. So
Exactly. So we compared the booking photos. The person that was on the camera, it was the person that was arrested for this case was before the court. So it's appropriate that he's arraigned. If he has an issue with identity, that's an issue for trial.
I agree with that.
we
So
need
if
to
we
arraign.
could arrange, I agree.
I've counted 4 FTAs, 2 continuances, and a multiple number of resets for SAP. So this has
I
become a
understand.
pattern.
We can arrange this case, but at the same time, Mr. Mr. Walker, this is a 2017 drive.
I know, and it looks like the defendant has been successful in his attempts to avoid his day in court. I mean, I take my hat off.
Basic rules. We're not gonna, okay, let's bring him back.
But
That's
the
not.
charade stopped today, to be clear.
Okay, we will, if at some point, Mr. Jacobs could be brought back, I agree. with
Andrew,
Mr.
Antonio, whatever he's going by today.
Right, we're gonna call him Mr. Jacobs. We're gonna arrange that case at some point today. I am inclined to agree with the state regarding that. However, I would ask and request that the state look at that case very closely in light of the age of that case as to whether we wish to go forward with that. But we will arrange it today.
Thank
and
you,
do
Your
the
Honor,
others.
and thank you for your indulgence.
I understand that. I hope you'll indulge me and look at that closely as well. All right, who do we have next?
Your Honor, if I can just intervene, I have a witness on, for, I don't know how long she has, for Mr. Parks. We have a negotiated plea in that case, so when you get a chance, I just want to let you know there's a.
Okay, I also am asking if we could take the case that belongs to Robert Reeves as well. So is it possible that we take Mr. Reeves' case and then shortly thereafter we take Mr. Parks? Is that possible? Who do you represent, Mr. Reeves? I apologize. I'm sorry, Mr. Adams represents Mr. Reeves. Is Mr. Reeves at courtroom too?
Do we have no, hold on, Judge. No, we don't have Mr. Reeves yet.
Oh, so Mr. Reeves isn't there, so we can't take that position. Could we take Mr. Parks?
Yes, he was actually gonna be the next person.
Wonderful, thank you.
John, Ed Adams, may I report to another court and come back?
I'm sorry, say that again, Mr. Adams?
Can I report to Judge McBurney's court and come back?
Yes, it seems like there's gonna be some delay. Yes, you may.
Thank you.
Thank you. All right, Mr. Parks, your case is 21 CR 005798J. In this case, you're charged with simple battery and family violence with the offense date of August the 3rd of 2021. You understand your rights?
Yes, ma'am.
All right, the announcement that I have, I don't have an announcement. What's your announcement, Ms. Watson? Thank you.
We have a global offer. He has 4 cases on his calendar, Your Honor. We have.
Oh, he does. You're correct. Let me read those other ones. I apologize. Mr. Parks, you also have 21 CR 005804J. And what you're charged with giving false name. And you also have 20 CR 005742J. In that case, you're charged with simple battery and theft by taking. And in the final case that appears on this calendar, 20 CR 5744J, you're charged with theft by shoplifting, giving false information to counts with the offense date of November the 17th. All right, I'm sorry, Ms. Watson, Cafe, please continue.
We have a negotiated plea on all four. It's a global offer, Your Honor.
All right, Ms. Backus, please give us state's global offer, as well as very briefly, one quick sentence supporting the factual basis for these cases.
On the simple battery family violence, it looks like it looks like 12 months, 110 days to serve, credit for time served, 55 days, balance probated, and FVIP, no further contact, and a third party transfer. The no further contact, the victim's name is Maya Hooten. Hooten is spelled Hooten. On the giving false info, I don't see that this is a global offer, because
I see different offers listed on the calendar for each one. So
I do.
My apologies. It's four separate offers, but they're running concurrent.
All right.
Yes, so for the giving false info, it is 12 months, 29 days to serve, credit for time served, 29 days, and balance suspended. On the simple battery family violence,
this would just be simple battery on position 23, that offer, Ms. Backus?
oh, that's actually ASG Campbell. She's got 23 and 24, I believe.
That's correct, Your Honor.
Okay, well, that's interesting.
All right.
All right, go ahead. You go ahead and finish, Ms. Backus, and then we'll go to Ms. Campbell.
I believe that for the simple battery family violence, I don't have much of I don't have a one sentence factual basis. But I believe that the defendant and Ms. Hooten, is this his mother?
You're not limited to one sentence. I just
Okay, you said that, and I'm like, well, let me find the one
make
sentence.
make it brief. The idea is brevity. That's all.
Okay. So basically this occurred back on the August 3rd of 2021. Officer went to 1993 Bent Creek Way, Southwest. Upon arrival, the officer was met by the victim and the defendant, spoke with Ms. Hooten, who said that she got to the location to retrieve some of her belongings that were at the defendant's mother's home. And Ms. Hooten said that when she and the mother began to argue, the defendant's mother began to argue. And then the mother and the defendant tried to fight her. The officer then followed them back to the other location, which was the defendant's home. The defendant then, I guess, fled the scene, I believe. Yes, the defendant fled the scene. And basically, Ms. Hooten was just saying that they were arguing because she was, I guess, being disrespectful to what he perceived as being disrespectful to his mother. And that's when he pushed her and he hit her in the face multiple times. What else did you want from me on this, Your Honor? Do you want the history or?
No, that's fine. Go to the next one.
Okay, and on this next one, that was October 26, 2021. Basically a gang unit. There was basically a unit that saw a vehicle, and when they ran the tag did not match the car, and so they pulled it over. And the males, they then had the male step outside of the car, and while they were standing outside of the car, the defendant was instructed to, I guess, stop moving, and he complied, but then he gave a fake name of Tenilius Daniels and a date of birth of 11/07/2000. And then when they asked him again, because they ran it and it didn't come back, and so when they asked him again, he said that Daniels was spelled a different way, and so that hence the giving false info charge.
All right, thank you. Ms. Campbell, if you would give us the offers for the other two positions, as well as very briefly the factual basis.
Yes, Your Honor. For positions 23 and 24, the offer is the same. And the offer is 12 months, serve 80 days, credit for the time served 40 days. The balance is to be probated. We're also recommending 8-week anger management and no further contact with the victim, Maya, the same victim, Maya Hooten, which is the mother of his child. And that is on the case ending in 42J, the no contact and the 8-week anger management. Since there's 2 counts, we're asking that that particular sentence is to run concurrent on both counts in the case ending in 42J. And as to position 24, it is the same offer, the 12 months, serve 80 days, credit for time served, 40 days, the balance to be probated. And there's 3 different counts. So that's to run concurrent on all 3 counts: the theft by shoplifting, giving false information to a law enforcement officer, and another count of giving false information to a law enforcement officer. We're also asking for a anti-theft course to be a condition of his probation on the matter ending in 44J, which is position 24.
All right. And if you would very briefly give me the factual basis for those 2 positions.
Yes, Your Honor. As to position 23, the factual basis is that on the date of August 11th, 2020, at the location of 1993 Bent Creek Way, Southwest, apartment J205, the defendant hit the mother of his child, Miss Maya Hooten, in her face, according to her. And according to her, he also stole $70 from her at that time. As to position 24, the factual basis is that on the date of November 7th, 2020, officers were dispatched to Walmart located at 844 Cleveland Avenue in reference to shoplifters in custody. Officers were made aware that this defendant and a female co-defendant essentially concealed baby items in a black book bag, and this defendant walked past all points of sale without paying for those baby items. The defendant gave officers a false name and a false date of birth. When the officers ran the information that the defendant provided, nothing came up. When they arrived at the precinct, they took his fingerprints, and when they got the fingerprints back, the defendant's true identity was revealed, and that was Jaquarez Parks, date of birth, November 14, 2000. Nothing further from the state as to the factual basis on that case.
All right, that was quite a lot, but Ms. Watson Cafe, do you stipulate to the factual basis, ID, and venue in each of these cases? And was that your understanding of each of the offers?
Yes, Your Honor. I do have Ms. Hooten on the call, however, and she is asking for no further violent contact as opposed to no contact.
Okay. So the plea is essentially sort of non-negotiated. Does your client still intend and wish to take the plea if we accept the state's recommendation? I will hear from the alleged victim in this case, though.
I will ask him, Your Honor. I'm not sure. They are expecting a child in February. He is, they plan to co-parent that child. I will ask him.
All right.
Is he in courtroom too? Or
is the alleged victim present?
Ms. Hooten? She was on here, Your Honor.
I'm here, but it won't let me turn on my camera.
Okay. I'm sorry. And I'm sorry. What position did you need, Ms. Grace?
It's on 5744J.
Which number is that?
Oh.
That was a Walmart one, I believe. Let me clarify that. Miss Campbell, on position 24, the death by shoplifting, was that the Walmart on Cleveland Avenue?
Yes, Your Honor. I do apologize. That is the Walmart.
What's the address? I know it's Cleveland Avenue, but I didn't know that.
844.
844 Cleveland Avenue. And that's East Point, I believe. 30344. All right. I need Miss Hooten to turn on her camera. So that if you wish to make a statement, Ms. Hooten, you need to, thank you.
I'm here. I'm sorry. I'm sick and I can't. But I'm here.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court at this time?
Yes. I would like the charge that is against him to be dropped in any kind of way if that's possible. We have 2 kids now, so I'm not scared of him. He's not a harm to me, and he's the father of my kids. So, and he's very helpful to me. So I would like for all this to really just go away if it could.
All right, thank you for making that statement. I appreciate you coming to court. Ms. Backus, can you give me the history, please, to support this case? I'm sorry, you may have given it to me previously.
No, I didn't, Your Honor. He had 16 cycles, starting back from, it looks like 2014. He's got 1 conviction, which is a 2018 disorderly conduct. 2014, these are arrests that I'm listing: 2014 theft by taking, 2014 theft by receiving, 2017 theft by receiving, 2019 pointing, aiming a gun at another, 2020 felony marijuana and possession of a Schedule I controlled sub, 2020 theft by receiving, fleeing, eluding, possession of a lot of charges. I believe that he's got another 2020 theft by shoplifting, 2 counts of giving false info. That one is open. It's 20 CR 005744J. Then he's got another 2020 simple battery theft by taking. That is open as well. 20 CR 005742J.
That's the case.
Oh, that's the same. That's the same. I apologize. So that
Mhm.
one is, he's already out on a $12,000 surety, and that's the same. 2021 possible or possession of prohibited item with an inmate, 2021 simple assault, family violence, another 2021 giving false info, 2021 battery, and a 2022, I guess that would be from last month, 4 FTAs.
Okay, so Ms. Watson Campaign, I'm just curious, is your client, would you like to speak to him to see if he wants to take the plea today?
I can.
No contact?
I can just ask him on the record. I'm sorry, I lost my video somehow.
We can still see you.
Oh, okay. Mr. Parks, can you hear me okay?
Yes, ma'am.
Okay, do you still want to move forward if you can't have contact with Ms. Hooten? If the judge orders that you can't have any contact with her?
Yes, ma'am.
He still wants to move forward, Your Honor.
All right, I will accept the state's recommendation as it pertains to each of these cases. So we're gonna move forward. We're taking pleas in case 5798J, the simple battery case, 5804J, the giving false information, 5742J, simple battery theft by taking, and the case ending in 5744J, theft by shoplifting, and 2 counts of giving false information. Ms. Watson Cafe, do you stipulate to factual basis, ID and venue? You may have done that previously, but I want to make sure.
Yes, I stipulate to a factual basis and venue in each of those cases.
Thank you. Mr. Parks, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone promise you anything in exchange for pleading guilty today?
No, ma'am.
Did anyone force you to take a plea today?
No, ma'am.
And you understand that you're not gonna have any further court dates regarding each of these charges if you take a guilty plea at this time?
Yes, ma'am.
And you understand that you have any other open cases that taking a guilty plea may affect those as well?
Yes, ma'am.
And you understand you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you understand the requirements of each of these, that you cannot have contact with Ms. Hooten, that there is a theft course that you need to take as well as some anger management courses. You understand that? And you cannot go back to Walmart on Cleveland Avenue? All right, as to those charges I previously listed, Mr. Parks, how do you plead?
Guilty.
I accept your guilty plea as it pertains to each of these cases. Is there anything further from the state or the defense?
Nothing further, Your Honor.
No, Your
Nothing
Honor.
for the defense, Your Honor.
All right, best of luck to you, Mr. Parks.
Hey,
All right,
we have Mr. Jacobs in front of the.
okay, we're gonna arraign that case, Mr. Jacob. All right, Mr. McLean, are you still present?
Yeah.
We are gonna arraign position 15. While we understand that there may be some issue as to the identity of the defendant, we believe that arraignment is proper at this point. So I'm gonna arraign Mr. Jacobs, all right? Mr. Jacobs, you've been charged in case 17 CR 02413G with 1 count of reckless driving, 1 count of driving too fast for conditions, and 1 count of driving without a valid license with the offense date of March the 21st of 2017. Mr. McLean, do you waive a formal reading of the accusations?
Your Honor, we do waive the formal reading. We have a copy of the accusation.
All right, at this time, this case will be reset for trial and the trial scheduled by a state court judge to whom the case is actually assigned. At this trial, you will have a right to an attorney just as you've had today, and you do not have the burden to prove these charges at the trial. The state represented by the Solicitor General will bear that burden. And if they do get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Jacobs, how do you plead to the charges I just listed? Do you plead not guilty?
I don't know how to plead. I don't, you feel me? I told Mr. McLean.
Okay, don't say too much. The state is listening. Do you plead not guilty or do you plead guilty?
I believe his silence on the matter would stand as not
It
guilty.
does. I just wanted to, I was hoping he would engage. All right, his silence, he's been formally arraigned at this time. All right, I believe that will conclude Mr. Jacobs' case. His case will be so reset to a division judge. Thank you.
Can we do position 14, Hale?
Yes, this is Torrance Hale. All right, in this case, excuse me, 22 CR 007531Y. You're charged with 1 count of battery family violence with the offense date of June the 24th. You understand your rights? Oh, you have not heard your rights. You have a right to remain silent. Anything you say regarding the facts of this case can and will be used against you. You also have the right to an attorney today, and this proceeding is being broadcast over the internet. That means any member of the public can watch it. You understand that?
Yes, ma'am.
All right, thank you. Mr. Bartels, what is your announcement?
Well, Your Honor, at this time, we're going to enter a not guilty plea. If possible, we would ask to be heard on bond.
All right, so we will arrange this case and then we will conduct the bond hearing.
Yes, ma'am.
We're on position 14. All right, Mr. Hale, in case 22 CR 007513Y, you've been charged with battery family violence with the offense date of June the 24th. Do you waive a formal reading of the accusation, Mr. Bartels?
We do.
Thank you for that waiver. At this time, the case will be reset for trial, and the trial will be scheduled by the state court judge to whom the case is assigned. At this trial, you will have a right to an attorney, just as you've had today. You do not have the burden to prove these charges at trial. The state represented by the Solicitor General bears that burden. If they meet that burden, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Hale, how do you plead?
Not guilty.
I accept your not guilty plea. Thank you. All right, whose case is this for the state? So that, oh, Ms. Backus. Ms.
Yes.
Backus, if you could give me the state's position regarding bond, I would appreciate it.
Yes, Your Honor. This defendant has 7 cycles, a 2011 Theft by shoplifting, where he pled, did first offender, 2017, misdemeanor marijuana. 2020, he's got an ag assault conviction. For arrest, he's got a 2012 probation violation, 2017, theft by taking, that was no pros, the 2021 simple assault, family violence, battery, family violence, and cruelty third, and an 11, sorry, let me get the date. Yeah, so, and then this month, I believe, he's also picked up on a battery, family violence. The state's, I believe he has a $10,000 cash bond in place. Based, is that correct? Did someone just say? Okay, okay. And the state would ask that that would remain in place based on the history. This incident occurred on June 24th of 2022. An officer was dispatched to the incident location, 1935 Allison Court, in reference to a disturbance. Upon arrival, the officer met with the caller, Kendricia Jackson, who at the time was hysterical. She said that she was in sleep when her boyfriend, child's father, who's the defendant, came in and tried to have sex with her, which she said no, because she was tired. She said the two of them began to argue when she advised him to get out of the room. And at that time, he got upset, started hitting her multiple times in the face. She was then thrown to the ground, and he placed his arms around her neck and began to choke her until she could not breathe. The victim stated he then let her go, where she grabbed their 1-year-old daughter, ran out of the house, and called the police. She was running out, and the defendant ran behind her, closed and locked her out of the house. The officer did observe swelling on her face as well as a busted lip. At the time of the incident, the victim was pregnant, Your Honor. And so based on the factual basis and the fact that he already has open battery, family violence, and he's got that 2020 ag assault conviction, we would ask that the $10,000 cash bond stay in place. He has not learned from his previous dealings with the justice system.
All right, thank you, Ms. Backus. Mr. Bartels?
Yes, thank you, Your Honor. First of all, I would note, of course, that Mr. Hale, this is still the preliminary stages of the case. He does enjoy a presumption of innocence, and he does dispute the allegations that the state has recited. We would ask the court to consider leaving the $10,000 amount in place, but converting that to a surety bond as opposed to a cash bond. There are some investigation of this case that would need to happen before it goes to trial, and of course his ability to assist our agency in his defense is seriously compromised if he's in jail. I believe a $10,000 surety bond would be sufficient to ensure his appearance. He does have ties to the community judge, his grandmother, his aunt, his mother, and I'm told his brothers and sisters all live in the metro Atlanta area. I'm advised that he is attending automotive technician courses at Atlanta Technical College. I'm also advised he works full-time at Team Auto Sales on Campbellton Road. Would also note, well, I was told that he believed that there was a warrant out, so he turned himself in at the jail on November 2nd. So he actually turned himself in as opposed to being picked up just any other way. So I believe a $10,000 good bond would be sufficient in this case to guarantee his appearance.
All right, and the 2021 case, I'm reading this, he has a repeat with the same victim. Is that correct? His backup?
Let me pull it up really quick. 1 second, Your Honor.
I'm just trying to clarify that point. That I see multiple cases, same victim.
Ms. Campbell, if you're trying to speak, you're on mute.
I'm sorry, that is correct, Your Honor. I handled it at the C calendar. And so, yes, it's the same victim in that case. And the judge, and he was, I'm sorry.
When you say multiple cases, it's more than two.
Well, in the other case here in state court, it was the same victim. He got a conviction, and the judge ordered him, it was Judge Law. Judge Law ordered him to have no contact with this victim. And so the reason why she set the $10,000 cash bond is because he was in violation of her order, and the victim is also now pregnant. So Judge Law's position was, not only did you have contact with her, but she's pregnant. and you've already been convicted for a violent act against her by the.
All right, thank you.
Thank
At this time, the bond will remain at set. Is there anything further from either party?
Nothing further from defense, Your Honor.
All right, best of luck to you, Mr. Hale. Who do we have next?
Mr. Bartel, the rest of the cases are here. Position 16 and 17 are for Mr. Bartel.
Oh, Mr. Bartel is gone.
Your Honor, I only have one more on this calendar.
Okay, then that's Mr. Williams. Can we do Miss Watson's Cafe's last position? Is he there, Don Trevius Williams?
Yes.
Can we take that position, please? And the announcement, Miss Watson Cafe?
We have a negotiated plea in this case, Your Honor.
All right, thank you. Mr. Williams, in case 21 CR 004179E, you're charged with 1 count of criminal trespass, 1 count of battery, family violence, and 1 count of reckless conduct, each with the offense date of July the 15th of 2021. You understand your rights?
Yes, ma'am.
All right. And Ms. Backus, please give us the state's offer.
I
as well.
apologize, Judge, I did not hear the position number.
31.
That would not be my case. Okay.
Oh,
It's Miss Harmon.
Miss who?
Miss-
Miss Harmon?
It's Miss Harmon.
Okay, Miss Harmon, are you present? Zoom doesn't always show me everyone who's assigned.
Bartel.
I will text her now, Your Honor.
Okay.
I
thank
do
you.
see her on. She just.
Oh,
made-
I do now that I scrolled over. I do see her as well. Ms. Harmon, are you ready to go forward on position 31?
Good morning, Your Honor. Yes, I'm.
Okay. We'll pick like 3 or 4 numbers out of there. Like I said, the other night when you walk in with the
All right, I like the state's position as well as the factual basis regarding the negotiated plea on position 31, Mr. Don Trevius Williams.
Good morning, Your Honor. It's Aaliyah Harmon for the state.
Mark H. Ryan or Ryan Simmons.
I'm sorry, I'm hearing
Ryan by himself.
something else. Can you give me one moment, please?
Yes, I think it says it's coming from your screen, but I don't know.
apologize. I had another video playing in the background. The state has had negotiations with defense counsel, and our recommendation in this case is for the battery family violence. 12 months to serve, 158 days, credit for time served, 158 days, balance probated, FFIP, no further contact with the victim in this case, Alonza Hunt, that's ALZANZA Hunt. I'm sorry, let me repeat that, ALONZA, last name Hunt, HUNT. Stay away from the incident location of 911 Glen Arden Way Northeast in Atlanta. In the probation can be non-reporting when the FFIP program is complete. We've also would not have any objection to any waiver of the probation fees if the court sees fit. Brief factual basis, Your Honor, is on the incident date of July 15th, 2021. Officers were dispatched to 911 Glen Arden Way Northeast in Atlanta to a fight in progress call. They did encounter the victim, Mr. Alonza Hunt, who advised that Mr. Don Trevius Williams, who was a roommate of his, that the parties were living with other roommates, and all the roommates had decided that Mr. Williams needed to leave the residence due to his violent behavior. Mr. Hunt advised police that Mr. Williams became upset, punching him repeatedly on the head and body. They were in a vehicle at the time when this incident took place. Mr. Hunt said due to the altercation, he took his foot off the brakes while being struck, causing the vehicle to back into a tree. When he got out of the vehicle, that's Mr. Williams, he picked up a brick and threw it into the windshield of the vehicle, causing the windshield to crack. Mr. Hunt then drove to a different location to report the incident to police. As it relates to the other charges, Your Honor, the state has agreed to null pros the reckless conduct and the criminal trespass, family violence in exchange for the guilty plea on the battery family violence with conditions. In review of his criminal history, he does have history out of Tennessee in 2012, which is a burglary. He does have 25 cycles in Georgia, primarily theft cases. Of note is a 2016 battery family violence that was null pros with the same victim, Alonzo Hunt. And he did have a recent conviction out of Cobb County in 2022 for simple battery. It's nothing further from the state on this.
All right, thank you. Ms. Watson Cafe, was that your understanding of the factual basis, ID, and venue?
Yes, Your Honor.
And was that also your, I'm sorry, you stipulate to the factual
I
basis,
stipulate,
right?
yes, Your Honor.
And was that your understanding of the offer?
It is, Your Honor, and as the state has already indicated, we are asking that probation go non-reporting after he complete the family violence intervention program, and also that the probation fees be waived. He's been in custody for quite some time, Your Honor, and just does not have the financial wherewithal to pay the probation fees at this time.
Because the FVIP is long, I'll waive 6 months. Hold 1 second, we'll be in a brief recess. All right, thank you all for that. We're gonna go forward taking Mr. Williams' plea. Mr. Williams, will you please raise your right hand? Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I think he's on mute, Your Honor.
I was gonna say, can we unmute him at courtroom 2?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time? Are you satisfied with Ms. Watson Cafe's representation?
Absolutely.
Do you understand that by pleading guilty, you're giving up your right to a full trial and there'll be no further opportunities for you to present evidence in your favor?
Yes, ma'am.
And you're prepared to waive that right?
Yes, ma'am.
And you understand that the requirements that you're also gonna have to complete a family violence intervention course, pay for that course, have no contact with the alleged victim, last name Hunt, in this case, and stay away from that address on Glen Arden Way. Do you understand that, Mr. Williams?
Yes, ma'am.
All right. As to the charge of battery family violence, how do you plead?
Guilty, ma'am.
I accept your guilty plea. I'm gonna waive 6 months of fees to assist Mr. Williams with completing that course.
Yep.
Is it, Ms. Harmon, yes?
Your Honor, I put it on the plea paperwork, but I don't think I announced it. We were also looking for no alcohol, drugs, or weapons during the balance of probation.
I believe that's understood, but yes, all right.
Your Honor, this case, I understand the drugs and weapons, but this case didn't involve any issue of alcohol. I don't see why he would be forbidden.
All right, we understood, Ms. Watson Cafe, no weapons and no drugs, all right?
Okay, thank you, Your Honor.
All right, anything further from either party?
Your Honor, I do have the null pros. I am in the building. If I could bring it to the courtroom, I just need to know what courtroom you're in.
I'm in G33, that would be ideal. Thank you, Ms.
Okay.
Herman. We appreciate that, thank you.
Yeah,
All right, Ms. Watson, yes, take care, have a great
Thank you, Your Honor.
afternoon. All right, bye-bye.
And Your Honor, me as well, that concludes my business. May I be excused?
Yes, you may be excused.
Thank you.
And best of luck to you, Mr. Williams.
All right, thank you.
All right, who do we have next?
16 and 17, Lee.
All right. All right, good afternoon, Mr. Lee. Your case is 22 CR 006781B. In this case, you're charged with 1 count of disorderly conduct, 1 count of obstruction, and 1 count of criminal trespass, each with the offense date of October the 8th of 2022. Do you understand your rights?
Yes, ma'am.
All right. And what is the announcement? Oh, and you also have the position 17, 22 CR 007581B. In that case, you're also charged with criminal trespass, obstruction, and in the additional charge of possession and use of drug-related objects with the offense date of November the 4th of 2022. Mr. Bartels, the announcement, please.
Yes, Your Honor, he has accepted the state's offer. It'll be a global resolution, and we'll proceed with the plea.
All right, so it's negotiated pleas for both positions.
Yes, ma'am.
All right, wonderful. Ms. Backus, please proceed. Please give me the history, state's offer, and very briefly, the factual basis supporting it.
Yes, Your Honor. The history, there's 8 cycles. Got for convictions, a 2012 DUI. I believe there's 2 DUIs in 2012, a 2014 criminal trespass, ag assault, false imprisonment. That one he did first offender. For arrest, 2012, driving while suspended, 2020, public order crime, criminal trespass, disorderly conduct, June 2022 FTA, June 2022 theft by shoplifting, and then our case, obviously. With the initial case, position 16, this incident occurred on October 8th. An officer was dispatched to the Citco gas station, 655 Cleveland Avenue. When he got there, the defendant immediately took flight. The officer was able to go in the rear parking lot where he attempted to run again, but he was apprehended, taken back to the Citco, positively ID'd by the store clerk. And he said the defendant had come in that morning and was pretty aggressive and made him fear for his safety because of the behavior he was exhibiting. And he had been warned several times to stay away from that location because they said that he continues to come there and steal and harass the customers and the clerks. On the global offer is 12 months, served 28 days, credit for time served 14 days, balance suspended, and stay away from the incident location, which again is the Citgo gas station at 655 Cleveland Avenue. In the second case, same location, and this one occurred on the 4th of November, and they basically, the store clerk flagged the officers down, and he was, again, obviously a repeat trespasser, and when they detained he was resisting and refused to follow the officer's commands, and when they took him into custody, they found a glass pipe on him, Your Honor, and so yeah, that's it. Nothing further from the state.
All right. Was that your understanding of the offer, Mr. Bartels, and do you stipulate to the factual basis ID of venue?
That is our understanding, Your Honor. We do stipulate to a factual basis, and Mr. Lee does understand that he can't go back to this location. So we would ask the court to accept the negotiated plea.
All right. Mr. Lee, please raise your right hand. I'm gonna ask you some questions. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Are you satisfied with Mr. Bertel's representation?
I am.
And you understand that you're not gonna have any further court dates regarding these two cases, and you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
I do.
All right. And you understand the requirements of the sentence, which essentially the time you served in the Fulton County Jail was closed for cases. However, you absolutely cannot go back to that sit-go. Do you understand that?
Yes, ma'am. Is that based on a 12-month?
You cannot go back there. Yes, it's 12 months, but you understand that you're not supposed to go back there as part of this.
Yes, ma'am.
They do not want you there. You understand that?
Yes, ma'am.
All right. As to the charges, Mr. Lee, that I previously listed, how do you plead?
Guilty.
I accept your guilty plea. Is there anything further, Mr. Bartels or Ms. Backus?
Nothing further. Thank you, Your Honor.
Nothing further, Judge. Thank you.
All right. Best of luck to you, Mr. Lee. That concludes your case. All right. Who do we have next?
13, Griggs.
And Your Honor, very briefly, can I ask Ms. Kasha to check her chat, the PD social worker, pretty please? Thank you.
Yes, you may. And we're starting to have people for the competency calendar arriving, so.
Yes, that's why I would like to chat with Ms. Kasha.
Right, hopefully we're almost concluded with state on purpose. All right, Mr. Griggs, is this that case position 13? The announcement that I don't have an announcement. Mr. Bartels, what's your announcement?
Well, Your Honor, I was able to speak to Mr. Griggs today. The incident date I have on this is June 30th of last year. He does not recall the particulars of what happened or didn't happen on that date. When I looked at the discovery material, there was an accusation which basically tracked the statutory language and said that he ran and didn't lie down, but it doesn't give any indication as to why the officer had any articulable suspicion to detain him anyway. So, given all that, I'm not comfortable with proceeding with a plea.
So today we'll be arraigning the case, Mr. Bartels?
Yes, ma'am.
All right, so let's do that. Mr. Griggs in 20 CR 007747F, you're charged with obstruction of a law enforcement officer with the offense date of June the 30th of 2021. Mr. Bartels, do you waive a formal reading of the accusation?
We do. I've read a copy of the accusation.
All right, thank you. At this time, the case will be reset for trial and will be scheduled by the state court judge to whom the case is assigned. Mr. Griggs, you'll have a right to an attorney at that trial, just as you've had today, and the state will bear the burden to prove the charges against you. If they get a conviction, you can face a sentence of up to 1 year in prison or a fine of $1,000. Based upon this information, Mr. Griggs, how do you plead?
Not guilty.
I accept your not guilty plea. The case will be so reset at this time. Is there anything further that should be addressed?
Nothing from defense, Your Honor.
All right, best of luck to you, Mr. Griggs. That concludes your case today.
Thank you, Judge.
All right, who do we have next?
Position 2, Bonnie.
All right. All right, good morning, Mr. Bonnie. Your case is 22 CR 007586E. In that case, you're charged with criminal trespass with the offense date of November the 4th. Do you understand your rights?
Yes.
All right, Mr. Bartels, your announcement?
Yes, that'll be a negotiated plea, Your Honor. The state's made an offer and he has decided to accept that.
All right, Ms. King, please proceed.
Yes, Your Honor, the offer is 12 months to serve 28 days, credit for time served 14 days with the balance suspended, no further contact and a stay away. The offense occurred on November 4th of this year. Officers were dispatched to 600 Peachtree Street Northeast in reference to damage to property. Upon arrival, they met with the victim, Demario Holland, Demario, last name Holland, who stated that the defendant busted the windows to the security booth on October 18th and then has since returned and did it again. I would also like to note that this was captured on video camera and the officer was able to see it, which led to the positive identity for the defendant. The defendant pled guilty to simple battery just last month, 22 CR 007048E, and he is still on probation. He also has a terroristic threats conviction from 2018 and 2 shoplifting convictions, one from November of 2018 and one from December of 2018.
All right, and I'm sorry, the stay away location I did get, Demario Holland is the person with whom he should have no further contact?
Correct.
All right, just making sure. Mr. Bartels, is that your understanding of the offer, and do you stipulate the factual basis, ID, and venue?
We do, Your Honor, and yeah, that is 14 days. He was booked on November 4th.
All right, thank you. I'm gonna ask you some questions, Mr. Bonnie. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No.
Are you satisfied with your attorney's representation?
Yes.
And do you understand that by pleading guilty, you're giving up your right to any further court date regarding this particular case?
Yes.
And you're giving up your right to have the state prove these charges against you?
Yes.
And did anyone promise you anything in exchange for taking a plea?
No.
Did anyone force you to take a plea today?
No.
And you understand that you absolutely cannot go back to that location on Peachtree Street? You understand that?
Yes.
And you can have no contact with Mr. Holland. You understand that as well?
Yes, ma'am. I don't even know who that is.
All right, as to the charge of criminal trespass, Mr. Bonnie, how do you plead?
Yes.
I accept your guilty plea. Is there anything further from either party?
Nothing from the defense, Your Honor.
All right, hearing none, best of luck to you, Mr. Bonnie. That's the end of your case.
We do have position 27, Mr. Reeves.
All right, let's go to that case. And I see Mr. Adams has returned. Mr. Reeves, in case 22 CR 0075440J. You're charged with 1 count of driving under the influence of alcohol, less safe, 1 count of driving while license suspended or revoked, 1 count of an equipment violation, your taillights, 1 count of possession of an open container, and 2 counts of obstruction, each with the offense date of November the 2nd of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right from attorney today. And your attorney, Mr. Ed Adams, is present on the Zoom conference and is able to assist you. This proceeding is being broadcast over the internet. It's also being recorded. Do you understand your rights, Mr. Reeves?
I do.
All right, Mr. Adams, what is your announcement for this case today?
Your Honor, we'll waive formal arraignment, plead not guilty.
All right.
Request to most be heard on bond, please.
All right, will you be entering that formal waiver of arraignment today, Mr. Adams?
Yes.
All right, let's proceed with the bond hearing. Ms. Campbell, please proceed.
Yes, Your Honor. The facts as alleged for this defendant are that on the date of November 2nd, 2022, at approximately 8:10 p.m., officers observed a 2015 Nissan Rogue, which they later identified the defendant as the driver of that Rogue. They saw that the vehicle didn't have taillights, and when they pulled the vehicle over, the officer immediately smelled a strong odor of alcohol emanating from the defendant's breath. When the officers began to ask him questions and ask him for ID, the defendant did not respond at all. The defendant simply just looked at the officer, and when he asked the defendant to step out of the vehicle, the defendant refused to step out of the vehicle. So he eventually had to be taken out of the vehicle by the officers. And when he was asked if he wanted to do the field sobriety test, he also refused to do those. He just refused to respond or comply with any of the orders that the officers were giving him. So the officers did take him into custody, and they did search the vehicle after taking him into custody, and they did find an open container of alcohol inside of the vehicle. Additionally, the defendant's history is very concerning to the state. The defendant does have 2 prior convictions for DUI. They're very recent convictions. One is from June of 2021 out of Cobb County. He was also arrested at that time for aggravated assault against a police officer. So he got the DUI and ag assault against a police officer on that case. He also has a 2019 conviction for DUI out of Cobb County. He was also convicted for simple battery and terroristic threats. Along with that DUI conviction, he also has a May 2022 conviction for driving while license was withdrawn out of Cobb County. His license was withdrawn because of the prior DUIs. And so we have him, here in this particular incident, driving again on a withdrawn license, the 2 prior DUI convictions. And I would also want to note that he has a 94 arrest for DUI as well. So in total, we have three prior arrests, 2 prior convictions for DUI. The bond as set is a $10,000 split bond. He has $5,000 cash bond on the DUI less safe. He has $1,000 cash bond on driving while revoked or withdrawn, sorry. And on the remaining counts, he has a $1,000 surety bond. So that's a total of $10,000 split. The state's recommendation is that the bond remain the same. And that's in light of the fact that the defendant is a habitual offender. He's an extreme danger to our community because not only is he drinking and driving, which endangers the lives of other motorists on the roads, but he's also doing it in multiple counties, Cobb County, Fulton County. Then we have that in combination with these DUI convictions and arrests, every time he is using violence towards the police. Because in this particular incident, he was non-compliant with the officers. They had to physically force him out of the car. What I didn't say was they essentially had to pull out a taser to even get this man to comply. So the state does believe that he's an extreme dangerous community because of the DUIs and the violent attacks on officers and all his DUIs. And the state believes that the $10,000 split bond is more than appropriate and would ask that it remain in place. He was also ordered not to drive at his last bond hearing, so the state would also ask that that condition remain in place.
All right, thank you, Mr. Adams.
Yes, Your Honor, those are the facts. But Mr. Reeves is self-employed, so he can stay work from home. We think it'd be more effective if he'd be placed on curfew or house arrest or that. The cash bond is no deterrent for what all that happens. So we're merely asking that the cash bond be changed to either house arrest or curfews. I think that'd be more appropriate and will accomplish more for the state.
All right, understand. Go ahead, Mr. Adams. Continue, Mr. Adams.
Yeah. He's not able to make the cash bonds, but surety bonds he can do.
All right.
He is self-employed. He's married with 2 daughters. Never has a failure to appear. So we request that, you know.
All right. Give me one moment.
Okay.
All right, as I'm calculating this, if there's anything further from either the state or defense, please make me aware at this time.
I do have prior FTAs for this defendant on in traffic court. So it's not listed on his criminal history, but on his traffic history, he has multiple FTAs and traffic.
All right. We will modify his bond only slightly. For count one, it will be a $2,500 cash bond, and all remaining counts will be $1,000 surety. So that will equal, and I'm terrible at math. Cash. I'm doing the math just to make sure. 1, 2, 3, 4. That's a $7,500 split bond with the same conditions: no driving whatsoever, no alcohol, drugs, or weapons as a condition of that bond. Is there anything further?
Yeah, can you repeat that one more time, y'all?
All right, count one, DUI is $2,500 cash. And all remaining counts will be 1,000 surety. So that he needs to make 1, 2, 3, 4, 5,000 in surety and 2,500 cash. And his case will be reset. Is there anything further?
No.
No, yeah.
All right, best of luck to you. And Mr. Adams, if that concludes your business before the court today, you are free to go.
Okay, thank you.
All right, best of luck to you, sir. All right, who do we have next?
Position 7, Foster.
All right, good morning, Mr. Foster. Your case number is 22 CR 006171D. I will not sound the charge, and I ask that the state not sound that charge either. In this particular case, with the offense date of December the 26th of 2021. Do you understand your rights today, sir?
Yes, I do.
All right.
Yeah,
I understand.
No, I would like to perfect the record about that. Are you saying that the state cannot sound a charge of a defendant?
I'm not saying that they cannot. I'm asking that they not in this particular case.
We've been instructed to do otherwise, so the solicitor will be sounding the charge.
I would object to that.
I object to it as well, and I'm going to request that the state not sound it.
So just to perfect the record, you're ordering the state that, or you're stating to the prosecution that we're not allowed to read a defendant's case or charge. And
I'm asking for the, let me hear the announcement, Mr. Walker, yes, let me hear the announcement, Mr. Bartels. What's the announcement for this case?
Well, Your Honor, I have reviewed the police report and the warrant. Given the allegations and the need to investigate further, which will take more time than we have had since getting that information yesterday, we would ask that the case be reset for approximately a week to a week and a half.
All right. I'm sorry, why are we resetting this case, Mr. Bartels?
Well, Your Honor, I just received the discovery on the case yesterday, and given the allegations and what is in the police report indicates that there could be some exculpatory evidence available from one or more witnesses.
So you think that we'll be able to take a plea in the near future, and you're not requesting that we arraign this case at this time?
I do not know what the disposition would be, Your Honor. I haven't had a chance to sufficiently investigate the case.
All right. We will so reset this case to next Thursday's SAP calendar. Give you 1 week, Mr. Bartels. It's my suggestion that you enter a waiver of arraignment prior to that date. All right?
Thank you, Judge.
All right, that concludes that case. Thank you.
Thank you, Judge.
Oh, next Thursday is Thanksgiving once again. So we will set it we'll set it next Tuesday, following Tuesday, the 29th.
29. All right. Thank you, Your Honor.
I hate to load that. Is that calendar? Let's look at that. Before we dismiss this case, let's go and see how heavy that calendar is. The 29th. And the state's objections are noted, Mr. Walker. However, we don't need to address that as this case will be reset.
Understood, Your Honor. Thank you.
Thank you.
Thank you, Judge.
And again, Mr. Bartels, it's my suggestion that to avoid this issue, you enter that waiver of arraignment.
Yes, we will address that promptly, Your Honor.
All right. We're gonna reset. We're gonna reset it for 2 weeks, unfortunately, because I think that Tuesday calendar is just too full. Let's check. We're gonna check Odyssey one more moment. All right, we're gonna reset it to 11:29.
11:29. All right, thank you.
All right, and that concludes this case. Best of luck to you, sir. Who do we have next?
Position 6, Dietz.
Mr. Dietz, your case number 22 CR 007534C, in which you are charged with one count of theft by shoplifting with the offense date of November the 1st. I have that there's no announcement yet. Mr. Bartels, your announcement?
Yes, Your Honor, I have spoken with Mr. Dietz and relayed the state's offer. That will be a negotiated plea. He is accepting the offer.
All right, thank you. Ms. King, please proceed.
The offer is 12 months to serve 32 days, credit for time served 16 days with the balance probated, a theft class, no further contact, and a stay away. This offense occurred on November 1st of this year. Officers were dispatched to 1000 Church Street, which is the Bim's liquor store, regarding a dispute. Upon arrival, they met with the victim in this case, Berhane, last name Mihretteab. And he stated that the defendant, the victim in this case was chasing the defendant down the street with a firearm. At that point, the officers disbanded the situation and got the firearm from the victim and went to speak with them. And he stated that he was working in this store and observed the defendant grab a case of beer and a bottle of tequila and ran out the store without paying for the items. At that point, the victim gave chase and did admit to drawing his firearm and firing a shot in the air. They also spoke with the defendant, who admitted to taking the items and fleeing the location. Both parties were arrested for this altercation. There's a probation violation conviction from 2022. There's an obstruction false name conviction from 2022. There's a probation violation from 2016, 2017, 2019, and 2021. Those are all probation violations convictions. There's also a first offender firearm by a convicted felon that occurred in 2016 as well. He also has 3 open cases, 2 criminal trespasses, and 1 marijuana possession, all from this year, Your Honor.
All right, thank you. And did you give us the offer? I'm sorry if you did.
Yes, 12 months to serve, 32
You did.
days credit for time served. Oh, you got it, okay.
You got it. Thank you. I did write it. All right, Mr. Bartels, was that your understanding of the offer? And do you stipulate to factual basis, ID, and venue in this case?
That is our understanding, Your Honor. We do so stipulate, and we would just ask the court to accept the recommendation, and we would ask that once he completes the theft class, that probation either go non-reporting or that it would be terminated.
All right, thank you. Please raise your right hand, sir. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes.
Did anyone force or coerce you into taking a plea today?
No, ma'am.
Did anyone promise you anything?
No.
And you understand that you're giving up your right to a trial by jury today?
Yes.
And you're prepared to waive your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand the requirements that you shouldn't have additional time to serve, but you have to attend a theft class, and you can have no contact with the victims in this case, and you have to stay away from that location on Church Street. You understand that?
Yes, ma'am.
As to the charge of theft by shoplifting, how do you plead? I accept your guilty plea. I believe that will conclude this case if there's nothing further from the state or the defense.
About probation,
In 1000 Church Street. I'm sorry, Mr. Bartels?
Would probation terminate or go non-reporting once he's done?
It can go non-reported once he completes the class.
All right, thank you.
All right, best of luck to you, sir. Who do we have next?
Position 20, Morgan. Come on, Mr. Morgan.
Didn't we do position 20?
We did, Your Honor. He's advised me several times, and as well as has advised the deputy, that he wants to go forward with his plea. I know the court sent some uncertainty, but he was clear that that's what he wants. So he would like to address the court again.
Okay, so he wants to take the plea at this time?
Yes, ma'am. And the court had indicated that the court would be adopting the state's recommendation.
Right, the recommendation will not change. So, Mr. Morgan, you do wish to go forward with this plea today?
Ma'am, yes, ma'am.
All right. I believe we've gone through the plea colloquy. I'm gonna ask you some questions. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you satisfied with your attorney's representation?
Yes, ma'am.
Did anyone force you into taking a plea today?
No, ma'am.
Did anyone coerce you into taking the plea today?
No, ma'am.
And you understand you will have no further court dates regarding these charges?
Ma'am, yes, ma'am.
And you understand that you're giving up your right to have a state prove these charges against you beyond a reasonable doubt?
Ma'am, yes.
And you understand that you can have no contact with the alleged victim, I believe, in this case? And that you will have some additional time to serve at the Fulton County Jail. You understand that?
Ma'am, yes, ma'am.
All right, as to the charges of battery, family violence, and battery against a pregnant female, I'm sorry, just battery, family violence, they're gonna merge. How do you plead, Mr. Morgan?
Yes.
I accept your guilty plea. Is there anything further from either party?
Nothing from the fence, Your Honor.
All right, best of luck to you, sir. I wrote them down, yeah. It's the ones that's on the calendar. Just confirm, Ms. Backus, for the record, the conditions that appear on the calendar, I did not strike through. I want to make sure that those are still applicable to Mr. Morgan's case. That he's to serve 12 months to serve 90 days, credit for time served 14 days, the balance on probation, that he needs to complete the FVIP, have no contact with the alleged victim, third-party transfer, and a one-time escort. Is that still correct, Ms. Backus?
That is correct, Your Honor.
And Mr. Bartel, you stipulate to that, that was your understanding of the offer, and you stipulate to factual basis, ID and venue?
That's our understanding, and we do stipulate.
All right, thank you. I just wanted to clarify. Best of luck to you, Mr. Morgan. All right, who do we have next?
Thank you, Judge.
Judge, my last three is for the competency. Are we able to start that?
I don't see Mr. Howard on the line. Yeah,
Your Honor, was there an announcement for position?
I don't think we've concluded all state.
Okay, my apologies.
No, we can't do competency just, is Mr. Howard on the line?
He said he was going to his car to sign in on Zoom.
To get in. Okay, he's not here quite yet. So we will go to, who do we have at South Annex?
Number 18.
All right, we will go to position 18. The case, are you Catherine Malloy?
Yes, Your Honor.
All right, Ms. Malloy, your case is 22 CR 0075288H. In this case, you're charged with battery and family violence. I'm going to advise everyone in South Annex of their rights. If you all could pay attention, please. You have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have the right to an attorney here at this proceeding today. This proceeding is being broadcast over the internet. It is also being recorded. That means any member of the public can watch this. The announcement I have that this is a conflict case. Is that correct? Is the conflict defender? I don't know that Miss Watson Cafe is gone. All right. I don't believe we can do this position today. Is that correct that she has a conflict attorney, Ms. Grace? No, we're on 18. Position 18. This case will likely be reset to Tuesday as her attorney is not present. Has that happened before? Position 18? Yes. The announcement sheet says that she has a conflict attorney, as does position 3. We're likely gonna have to reset both position 3 and 13 until the 29th as well, as there's no conflict attorney. Ms. Backus, were you going to make an announcement?
Oh, no. I was just looking at the events to try to see if it had been reset before, but I don't see that it has.
Ms. McLeod represents position 3 and 18. So we will have to reset those cases until state our purpose on the 29th. All right, I'm sorry, I apologize, Ms. Malloy, your attorney's not present and you need your attorney's representation today. So we're gonna reset your case to the 19th, I'm sorry, the 29th of November, all right?
Okay.
All right, best of luck to you, we'll see you then. All right,
Position 4 and 5, Ms. Davis.
all right, and did you hear my announcement for position 3?
Yes,
Ms.
ma'am.
McLeod, all right, thank you, we'll have to reset those as the conflict attorney does not appear. And if I had been made aware, we could have asked Ms. Watson Cafe, but, all right. We're on position 4 and 5, Ms. Davis. All right, Ms. Davis, your cases are 22 CR 007590A. You're charged with theft by shoplifting, obstruction, and criminal trespass with the offense date of November the 3rd. And you're also charged in 22 CR 006775A with theft by shoplifting, criminal trespass, and possession and use of drug-related objects with the offense date of October the 8th. Do you understand your rights?
Yes, Your Honor.
All right, Mr. McLean, I have that these are negotiated pleas with a global offer. Is that correct?
You're muted, Attorney
Ms.
McLean.
McLean, if you're speaking, you're muted.
Green. Oh, I see.
All right,
That is correct, Your Honor. I'm sorry, the microphone was green, but apparently the keyboard was not.
That's all right. Ms. King, please proceed.
The global offer is 12 months to serve 34 days, credit for time served 17 days with the balance probated, 2 theft classes and a stay away. It is the same incident location for both offenses, is the Walmart located at 835 Martin Luther King Drive Northwest in Atlanta. The first offense occurred on November 3rd. An officer was called out to a theft in progress. When he got there, he saw the asset protection associate that stated he observed the defendant on several previous occasions, shoplift, and she was back again. She was there stealing clothes, Your Honor, and she had placed them into 2 plastic Walmart shopping bags. And she did pass all points of sale without paying for them, and she was taken into custody. In the second case that occurred October 8th of 2022, she was back at the same Walmart. This time she took, it just says several items in this one. And that's when, in search incident to arrest, they found the drug-related object of a crack pipe, Your Honor. So we're asking for the stay away from that Walmart and the 2 theft classes.
All right, was that your understanding of the global offer, Mr. McLean? And do you stipulate to the factual basis, ID, and venue?
Yes, Your Honor. It is our understanding of the terms, and we do stipulate to those 3 items in each of the cases. For no particular reason, the cases were reversed chronologically in order on the calendar, so that the October thing did, of course, happen before the November thing.
All right, understood. I'm gonna ask you some questions, Ms. Davis. Please raise your right hand. Do you swear in from the testimony you give for the limited purposes of taking a plea today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Did anyone force you to take a plea today?
No, Your Honor.
Did anyone promise you anything in exchange for taking a plea?
No, Your Honor.
Are you satisfied with your attorney's representation?
Ma'am?
Are you satisfied with your attorney's representation?
Yes, Your Honor.
All right, and you understand that you're giving up your right to a trial by judge or jury today by taking a plea to both of these cases?
Yes, Your Honor.
And you understand the requirements that you have 2 theft classes to complete, and you absolutely cannot go back to the Walmart or Martin Luther King Jr. Drive. However, the time you've served in the Fulton County Jail, you should not have additional time. You understand that, Ms. Davis?
Yes, Your Honor.
All right, after the charges are previously listed, Ms. Davis, how do you plead?
Guilty.
I accept your guilty plea. Is there anything further from the state or the defense?
Nothing from the state.
Nothing, Your Honor.
All right, best of luck to you, ma'am.
Thank
That
you, Your Honor.
concludes your case. I believe that's the entire state all-purpose calendar.
Did we address position 3?
Position 3 is gonna have to be reset because that's also Ms. McLeod's case.
Got
And
you. My
there's no
apologies.
conflict of interest. Yes. So I believe
And you're
that.
not,
Go ahead.
I have a Naomi Campbell on behalf of the state. I have an updated announcement on position 25.
All right, that one is not being transferred to the DA?
No, it's not. Well, it's been rejected.
Okay,
And sent
so
back down to state court.
is that particular defendant there today?
Mr. Pettitan.
Is position 25 there?
Is Pettitan here in number 25?
Oh, and nobody has spoken with him either,
No,
I'm
Your Honor.
assuming. All right, so that case likely will have to be reset as well. Let's see. Is the 29th not completely full, Ms. Grace?
We do have, position 22. No, that's,
I'm sorry, we took care of position 22, did we not? I have the 22, we took a plea.
okay.
Position 21 and through 24 were the same person and we
With the
took a plea
same
on all of
person,
them.
so we took a plea on those. 25 is the only one, and we'll have to reset that case to the 29th as well, I believe, unfortunately.
Okay, thank you.
Your Honor, my understanding of the procedure in 28 and 29 is simply that I will inform him that case has been referred to the mental health court. And I'll make sure that he understands.
All right.
And I think, Mr. Bartel, I think he's already in mental health court. So he should be familiar.
That's
Okay.
correct. He's already in it.
That's what it says here as well.
Yeah, I think he just had a hearing on the 10th, maybe. But
I haven't, it's been on here, essentially. All right. That was 28 and 29 they were discussing now. And 25 is gonna be reset to the 29th. All right, I believe we've concluded the state all-purpose calendar. If we could review that, Ms. Grace, before we begin the DV reset calendar, as well as the competency, so that those who are not involved in those may be free to go to lunch.
You too?
Oh, was it? Let me see. Position 2 on the add-on, I read earlier that he refused to participate. So, Mr. McLean, is that your client? That's Mr. Bartels.
That was mine, Your Honor. I attempted to talk to him yesterday.
All right, since he's refusing to participate, are you gonna waive arraignment and we reset that case for the notice? Or what is your request, Mr. Bartel?
Does the record indicate whether an evaluation has been requested, Your Honor? Because based on the circumstances and what I've been told by jail staff, that may be appropriate if it hasn't already been done.
I don't have the history on this case at all. I don't believe that there has been one. Let me see what we can determine.
It was last in on Tuesday, and I don't believe that one was requested either.
So are you requesting one at this time, Mr. Bartels?
Yes, Your Honor, I think out of an abundance of caution, that would be appropriate.
So will you be submitting the paperwork, Mr. Bartel?
Yes, I will.
Thank you.
All right, where will we, in light of that, we need to reset it to a competency calendar.
Maybe Mr. Howard's on the line, so I don't know, maybe 2 weeks out, 6 weeks out,
It's gonna need some time.
whatever.
Okay. So let's reset it. Let's give it at least to December the 8th, at least to check on it. Let's order that.
December the 8th.
Send that eval. All right.
Okay, should I sign the order? Should I send the order to Your Honor and
Send it to Melissa Grace, please. She's assisting me today. All right. Now I believe that actually does conclude state all purpose. So let's review the calendar. Position number 1.
is a plea. Position number 2 was a plea. Position number 3, reset 1129 SAP. Position number 4, 5, and 6 were pleas. Position number 7, reset 1129 SAP. Position number 8, 9, 10, 11, and 12 were pleas. Position 13, reset jail jury. Position 14, reset jail jury. Position 15, reset jail jury. Position 16 and 17 were pleas. Position 18, reset 1129 SAP. Position 19 and 20, 21, 22, 23, 24 were pleas. Position 25, reset 1129 SAP. Position 26 was a plea. Position 27, reset jail jury. Position 28 and 29, reset to the MMC calendar. Position 30, 31 were pleas. Position 32, reset jail jury. Position 33, reset jail jury. Position 1 on the add-on was a plea. Position 2, reset 12-8 competency calendar. Any questions or concerns?
Any comments, changes, corrections, or questions? All right, hearing none, that concludes the state all-purpose calendar. Those who do not wish to join us for the DV reset or competency calendar are now free to go. See everyone next Tuesday. If I've not seen you before then, enjoy your Thanksgiving. Let's begin with the DV bench warrant case, the case of Terrence Goss. Perhaps
Good to see you.
all right, great. Take care, everyone. Is Mr. Goss on the line or his attorney?
And Your Honor, I do not see the defendant. For the record, it is at 11:55. The calendar was scheduled for 11. I would ask that, well, obviously you're not going to set aside the bench warrant because he's not here, but I would ask that the record be reflected that he FTA yet again.
Yeah, that is.
I'm not sure if another bench warrant should be issued. I mean, we could out of precaution.
And I don't know that, can I do a second one? I'm not sure that you can.
I don't think there's any rule that says you couldn't, but
I'm not sure that practically that makes a whole lot of sense.
I mean, this is his court date that he requested, so.
Who represents Mr. Goss? It's the public defender's office. So is it you, Mr. I mean, I see Ms. Giddings' name is down, but does any member of the public defender represent that defendant?
We'll look into it, Your Honor.
And to perhaps figure out why he's not here today?
We'll try to get in touch with him.
Okay. Well, bench warrant is still active and we will we'll note the FTA for the record. All right. I guess that was the fastest DV bench warrant case. For the record, Mr. Walker, was there an offer on this case at this time?
Let me check.
I would like Mr. McLean to be able to take an offer back in the event that they are able to make contact with this defendant.
So I did review the facts. It would be 12 months to serve, 180 days. I'm not sure what amount of time he's served in jail, but for any time that he has served in jail, of course, we would give credit, the balance to be probated, FVIP, and no further contact with the victim.
All right, Mr. McLean, did you get that? I'd like the public defender's office to please convey that offer over to the defendant, should you be able to make contact with him. All right?
You got that, Your Honor.
All right, thank you. Take care, courtroom 2. Enjoy your lunch. Bye-bye.
Oh, Judge Williams, I'm sorry.
Oh, you're there to do the competency calendar. I forgot.
Yes, yeah, we still.
We're ready to begin.
Okay.
I was hoping that you all didn't have to join us, but you will. Mr. Howard and Mr. Walker, if we could all go into our breakout with Miss.
And we can include Miss King as well. She's going to
Yes, Miss
help me
King
out.
as well.
Judge.
Yes.
I'm here on position 14 for the competency.
All right, thank you.
Bye-bye. Everybody have a seat in the second row.
Oh, Mr. Harris, all right. Is the young lady who was here earlier still here? Or she left? A family member was here for a member of the for one of the competency calendar.
I don't think it was competency. It was, what was the other private attorney? Oh, was it, she got what she needed. She was just trying to find out how much he needed to be bonded out. He had a split bond, 2,500 and 5,000.
Oh, so it was not the competency calendar. Okay,
Yeah, what you needed.
okay. All right. All right, yes, excuse me, Ms. Harrison. All right, let's begin with the competency calendar. If I could be placed in a breakout with Mr. Walker, Ms. Howard, and Ms. King. And for the record, Mr. Murphy is in the courtroom here with me. I don't have an objection to him being part of our breakout as well, unless the state or Mr. Howard has any other objections.
Well, Judge, we can, if we do his case first, then he can.
Right, right, let's do Mr. Murphy's case first.
And Kasha will need to be placed in as well. Kasha.
Oh, yes, please. All right, we will be on a brief recess while Mr. Howard speaks with position 1 on the competency calendar. Before we begin, Madam Interpreter, please state your name for the record.
Good afternoon, Your Honor. Yes, it is Ada, A-D-A, Lien, L-I-E-N.
Miss Lee, is it Lean? Is that how I pronounce your last name?
Lien.
Lean. Miss Lean, please raise your right hand.
Yes.
Do you swear and affirm that you will make an accurate translation from Spanish to English, English to Spanish, according to the best of your skills, knowledge, and ability?
I do, Your Honor.
All right, thank you. You will remain sworn in. We're gonna be in a brief recess so that Mr. Howard can speak to the client with interpretation. All right.
Judge, she just went off.
I'm sorry, I'm here. Mr. Ayala Gonzalez has to get interviewed by Mr. Howard with the benefit of Spanish interpretation. Is there some place?
Is it possible we can do, because he has to go back to Cobb County, Mr. Reed, Samuel Reed, position 18 on a competency? Because we have to send it back.
We'll try to do that one. The only problem is interpretation is only here for a few minutes. And we're trying to take a plea on position 1. Can that position hold one moment?
All right, Judge.
Or I probably can do, Mr. Howard, can I, we can probably do position 8. Let's see if we can do that one really quickly. Mr. Walker is gone, isn't he? Is Mr. Walker gone?
They're gonna do your case now.
Yes.
I let him take a break. Let's see.
And Judge, ultimately, we're just asking for
a reset.
A reset, right? He's being held well, yes, yeah, we're asking for a reset.
Okay.
So that we can do some more.
I'm assuming Mr. Walker will not object to a reset of that date. So we're gonna reset him to what, the 15th?
Yes.
All right, Mr. Reed, your case is being reset on this calendar to the 15th. Mr. Howard will make contact with you prior to that date and explain what's happening. All right? All right, so that concludes your case and you'll be free to go from here today.
Okay,
all right?
Come on, Mr. Reed.
All right, now, if Mr. Howard can get in with Mr. Gonzalez. The only problem is all of courtroom 2 is gonna be there, I believe.
Right, and we can, maybe if you want to quickly do the others, Judge.
Yes, for position 13, Mr. Gray. Come on, Mr. Gray.
Mr. Walker's not here.
Oh, that's right. Is he?
We
is he
can't
in a
really
breakout
do-
still?
He's not here. He's on a brief recess.
That's right. That's right.
Oh, Mr. Gray's case, we did address. Mr. Walker's not here.
Unless Ms. King is prepared to address it for Mr. Walker.
How you doing, Manuela?
Hi, good afternoon.
Good afternoon.
Ms. King, since we've already addressed this case in breakout, I know Mr. Walker, so I did say brief recess, but we've already discussed this case in breakout and we're resetting Mr. Gray to December the 1st.
Yes, and ASG Walker was in agreement with that.
Okay, so we can reset. Mr. Gray, your case is gonna be reset, okay? You'll need to speak to Mr. Gray.
No, ma'am.
Is he this is Mr. Gray?
That is Mr. Gray, Judge. And just to recap, Mr. Gray, I'd asked the court to release Mr. Gray. He's charged with 1 count of criminal trespass, at the Marriott. And I'd asked the court to release him on a signature bond today. And the court,
the court is requesting
advised
additional Mr. Gray, I'm requesting additional information, so I'm not going to grant the signature bond today. We will consider additional information and we will revisit your case on December the 1st, all right? So Mr. Howard will be in touch with you. He did make strong arguments. The court has some information that it needs to review first. So your case will be reset to December 1st, all right? All right. Now, I'm just confirming that the birth date is correct for Mr. Gray. You sure this is Mr. Gray? All right.
Yes, it's November 30th, I believe. Well, Mr. Gray, what's your birthday?
I'm the 30th, sir. I'm gonna turn 40, and you know what I'm saying? And this is my first time in Atlanta, ma'am. And I'm gonna turn 40.
Okay, I don't want you to tell us too much, Mr. Gray. The state is listening, but I am gonna reset your case, okay?
Okay, so okay,
go ahead. I don't want you to say too much. He's muted. Okay, Mr. Walker, I understand that we were on a brief, you were on a recess, you're not in trouble. We've only addressed the cases that you had previously consented to because the jail is, had
I'm
some other.
sorry, I
exigent-
thought we were doing it in the breakout session.
We're, the jail had some other exigent circumstances before we could get into that plea.
Okay, can I speak to her until I'm gonna have a warrant set up for Athens, Georgia? And how the hell I can't be released? Let me speak to the judge, please.
Okay, Mr. Gray.
Ma'am, I'm gonna have a warrant for Athens, Georgia. That's what I'm saying is I wanted to be released so I could go because on November 20th, I'm gonna have a warrant, ma'am. That's what I wanted to explain to you, honey.
You're gonna have a what on the
A
20th?
warrant for Athens, Georgia, ma'am.
Keep your mask up.
Okay, yeah, no, don't say too much.
Mask up.
Mr. Howard, will you speak with him regarding this? I guess he's telling me that there's someplace else he would need
That's
to
what I'm
be.
saying. I have to go to Athens, Georgia on November 20th. And I wanted to be at least for my birthday before I go back to Athens, Georgia.
All right, Mr. Howard, I understand that, Mr. Gray, but there's some information I need to receive first regarding
It
this.
might as well as be transported to Athens, Georgia immediately so I could be to this court date, man, on November 20th. I'm saying that I got another pending charges.
So, Mr. Howard, are you aware of what he's talking about?
I'm not showing a whole judge for Athens, but I mean, I don't know if he has a court date there that he, or sometime, I think the 20th is Sunday, but
I got to go on November 20th and the judge said I have to be there. That's why I wanted to be released so I could go and have
Well,
it.
I understand all of that, Mr. Gray, but there is some information that the court needs to receive before we can take any
Information
action
like
on
what?
this case.
Information like what? I don't have nothing.
I'm not gonna say it on the open record here, Mr. Gray, okay?
But she said.
All right, Mr. Gray, perhaps you can assist him with that, Mr. Howard. I don't know if maybe a call, I know that might be beyond the scope, but maybe a call to ascertain what that
Your
might
Honor,
be.
Your Honor, full disclosure with the court, I do see on his GCIC cycle 7 that he has an open case, Athens, Clark County. That may be where he's referencing their arrest date was September 2022. I just want to provide that information to the court.
Okay, we'll discuss that further.
Mr. Stafford.
Okay. We still gotta get to interpretation. We really do. I understand you're trying to complete at courtroom 2.
and Mr. Stafford's just an announcement, Judge. He was on the show to confirm he was released. He was not released because we need to redo the order for him to be released tomorrow morning. Ms. Walker, that was one of the ones I sent you. We just need to change the order, Judge, so that's so that he can be released tomorrow because they weren't able to release him yesterday.
Okay, have you already sent me that order?
I have not, Judge. I hadn't sent it out. Come prepared as soon as we're done and send it over.
Okay. 21.
So that's all we need.
Again, Mr. Howard, where is he being placed? Is it Gateway?
Yeah, he was going. No, he's going. He's got a place over. He has an apartment at Oak Street, but he's going to follow with the VA as far as everything else. But we were going to take him. We're going to transport him home.
Okay.
Okay.
I investigated. Yeah.
All right, is that the last case at courtroom 2 other than the interpretation? So can Mr. Howard?
I'm sorry, Judge, we had a little bit going on over here. Did you guys complete position 22, Mr. Stafford?
Yes, Mr. Stafford, they're gonna send me an order for his release.
Okay, thank you.
All right, so now can courtroom 2 go into the breakout with Mr. Howard in interpretation? And again, we will really be on a brief recess this time, Mr. Walker.
Okay, I'm sorry.
No, that was not on you.
Hello, Judge. Think we are ready to
All
proceed.
right, wonderful. And very quickly, we're gonna take the interpretation case. Can I be taking a breakout very quickly with Mr. Walker, Mr. Howard, Ms. King, please,
Okay.
and Kasha, please.
All right.
And then we'll take that, please.
All right.
I actually think we could just rejoin ourselves, right? Or
I do not, I thought that, I
yeah,
don't think
I take
no.
that back. Yeah, I don't.
it doesn't, it normally you can, but
Yeah, you're right. I'm sorry.
You got the 18th.
Wow, this is so cool. Jeez.
So you think that we started off filming?
She was bringing back my coat one. Well, she, I think me now. She came in. Oh, my God. You want to know how I'm sleeping. So. She should be moving here. You know, I'm gonna feel what to do. Yeah. There's only two children now.
selfish on paper, to me, maybe what I want. I know, so, maybe I don't like it, I just want to talk, I just want to be with the children.
Excuse me, courtroom two, you are not on mute.
All right, Madam Interpreter, are you still here with us? Ms. Lean, are you here?
Yes, yes, Your Honor. It's just that
All
I
right.
was connecting my
Thank
headphones. Yeah.
you. We're ready to proceed.
Okay.
All right, Mr. Carlos Ayala Gonzalez, I'm Judge Melanie Williams.
Señor Carlos Ayala González, yo soy la juez Melanie Williams.
In this case, 22 CR 005721Y.
En este caso, el número 22 CR 0057221Y.
You're charged with loitering and prowling and criminal trespass with the offense date of August 26th.
Okay. A usted se le acusa por los cargos de merodeando y holgazaneando y también por allanamiento de morada con fines delictivos que ocurrió el 26 de agosto del 2022, Your Honor.
Yes.
Okay, del 2022.
You have a right to remain silent.
Usted tiene derecho a permanecer callado.
Anything you say can and will be used against you.
Cualquier cosa que usted diga puede ser usado y será usado en su contra.
You have a right to an attorney.
Tiene derecho a tener un abogado.
And this proceeding is being recorded. Do you understand those rights?
Y este proceso está siendo grabado. ¿Usted entiende todos estos derechos?
Sí.
Yes.
All right, Mr. Walker, if you would give us the state's offer in this case.
Yes, I will. If Ms. King can just briefly give us the defendant's history, if you don't mind, Your Honor.
Very briefly, Ms. King, the history.
It's only 2 cycles. He has a arrest from Roswell, criminal trespass and harassing phone calls, and his second arrest is a FTA out of Roswell from 2013.
Okay, and that first cycle was what year?
Well, let's let Ms. Lean catch up. Go ahead, Ms. Lean.
Tuvo un Your Honor, can she please repeat and pause? It's really hard.
Yes, please repeat, Ms. King.
There is a 2010 criminal trespass and harassing phone calls arrest.
Okay, tiene un arresto por entrada ilegal y también por llamadas de hostigamiento
And a
en el
failure
2010. Go ahead.
And a failure to appear from 2013.
Y también por no comparecer en el 2013 en Roswell.
Okay, and the state's offer is 12 months to serve 168 days, credit for time served 84 days.
Okay. La oferta que está haciendo la fiscalía es de 12 meses con 168 días para cumplir y se le da crédito por los 84 días que ya tiene.
Balance suspended with no contact with Brian Smith, Janice
que se va a suspender y no puede tener contacto con Brian Smith,
Riggs, and Matthew Woodward.
Y Matthew Woodward.
Also, a stay away.
También tiene que mantenerse alejado.
700 River Bluff Parkway.
De 700 River Bluff Parkway.
And 800 River Bluff Parkway.
Y del 800 River Bluff Parkway.
On August 26th of 2022, Roswell PD responded to the incident location.
El 26 de agosto del 2022, el Departamento de Policía se acudió a estos sitios que se mencionaron anteriormente, de Roswell, el Departamento de Policía de Roswell.
At that location, the homeowner, Mr. Smith, advised that he was woken up by a loud noise.
En ese momento, el señor Smith, que vive en esta residencia, dijo que lo había despertado un ruido muy fuerte.
He went outside to discover several items on his front porch, rearranged and thrown around.
Y también él se dio cuenta y fue al porche o al porche de enfrente de la casa y se dio cuenta que había unos artículos o unos objetos que habían sido movidos y estaban todos en desarreglo.
He also observed his white Mercedes, which was covered in a tarp, to be
También observó que su Mercedes blanco, que estaba cubierto con una lona,
with the doors open along with the trunk open to be ransacked.
que tenía las puertas abiertas y también el maletero abierto y que había sido saqueado.
At that time, the law enforcement officers did form a perimeter around the location.
En ese momento, los agentes de policía cubrieron el sitio haciendo un perímetro alrededor del sitio.
They discovered the defendant in the rear of the home with a 2x4.
With a what? I'm
A
sorry.
2x4 wood board.
Ok. Se dieron cuenta que encontraron al individuo en la parte de atrás de la casa con una tabla una tabla de 2x4.
At that time, the defendant was apprehended.
En ese momento arrestaron al acusado.
Subsequently, the neighbor, Matthew Woodward, came out and spoke with law enforcement.
Después de esto, el vecino Matthew Woodward que salió afuera y habló con los agentes de policía.
And reported that his tool shed had also been broken into and ransacked.
Y también dijo que se habían metido en su caseta donde tenía las herramientas y que también la habían saqueado.
At that time, the defendant was taken into custody and warrants were taken out on the charges that were read before the court earlier.
Y en ese momento se detuvo y se tuvo bajo custodia al acusado y se pronunciaron las órdenes de arresto que se refirieron a estos cargos.
The state will be requesting a guilty plea due to the facts of this case. This very easily could be entering auto or a felony, and I think a guilty plea is the most appropriate plea.
El Estado también está recomendando que de acuerdo a cómo fueron los hechos de que se estuvo saqueando un carro y se manipuló con un carro, pueden ser unos cargos de delito grave y por lo tanto están pidiendo que se declare culpable.
All right, Mr. Howard, was that your understanding of the offer? And do you stipulate the factual basis, ID, and venue?
We do, Judge. That is our understanding of the offer, with the exception that we're asking that it be entered as a nolo contendere plea.
La oferta la entendió el abogado de esa manera como la dijo el fiscal, con la única diferencia de que se va a declarar nulo en lugar de culpable.
All right, at this time, if the defendant takes a plea today, I'm gonna find that he needs to plead guilty. Mr. Howard, does he still wish to move forward?
En este
Go ahead.
En este momento determino que el acusado se tiene que declarar culpable, quiere proceder de esta manera, le está preguntando.
And Judge, given his limited memory about some of the events, he wants to resolve the case.
Sí, señoría, debido a que él no recuerda mucho, la tiene limitada el recuerdo de lo que ocurrió, él quiere resolver su caso hoy aquí.
Which is why he was comfortable entering a no contest plea as opposed to a guilty plea.
Por eso se sentía más cómodo en declararse no lo disputa que en lugar de declararse culpable.
I don't believe we heard anything in his history that he had entered a nolo plea previously, Judge.
No hay ninguna mención en su historial de manejo, en su historial antecedentes penales de que se haya declarado nulo anteriormente.
And for all intents and purposes, everything else, he served significant time for this. And we would ask that it be entered as a nolo. Additionally, we'd ask that it be entered as 11 months and 29 days for immigration purposes.
Debido al tiempo que le ha pasado en la cárcel, estamos pidiendo de que se le acepte que se declare nulo y de paso también que por favor sea una condena de 11 meses y 29 días para cuestiones de inmigración.
If I could respond, please.
¿Puedo responder, por favor? Dice el fiscal.
To address the request of 11 months and 29 days, there's no objection to that.
The court was going to grant that.
Okay, there's no objection.
No hay ninguna objeción de que se le dé una condena de 11 meses y 29 días y la juez está de acuerdo con esto.
As far as the defendant not using a nolo in the past, as we all know, the whole 1 in 5 is a DDS guideline, so that's not necessarily applicable.
En relación a que se declare nulo, que no haya usado en el pasado, tiene que ver con las leyes que bajo los cuales se tipifican estos delitos, que no encaja con esto.
And as far as the defendant not recalling the events, that is very believable because what I admitted in the factual basis was the officer notated that his pupils were very dilated and he appeared to be under the influence of some type of drug and or narcotic.
Y en relación a que el acusado no recuerda los eventos que pasó realmente, es porque el oficial se dio cuenta de que tenía las pupilas dilatadas y que estaba bajo los efectos de algún tipo de alcohol o de narcóticos.
So based on the fact that there's 3 different victims and the factual basis of this case and the seriousness of it, the defendant not really recalling the events and him being inebriated, the state would reiterate that only a guilty plea would be acceptable.
Debido al hecho de que habían 3 víctimas en este caso y de naturaleza del tipo de cargos que hubo y por el acusado de no recordarse de lo que había ocurrido, la fiscalía continúa pidiendo de que tenga que declararse culpable y de que estaba bajo los efectos de drogas o de alcohol.
And those are really the reasons we're asking for a NOLO, Judge, because he is willing to take a measure of responsibility by entering a no contest plea to resolve the case. But that's why we're asking for a no as opposed to guilty, given what he's explained to me, Judge.
Y por eso que estamos pidiendo que se declare nulo debido a lo que él me explicó a mí, que está dispuesto a aceptar la responsabilidad de lo que ocurrió y por lo que dijimos anteriormente, es que él desea, estamos pidiendo que le permitan que se declare nulo, pues.
I've already decided that he would have to use the guilty if he wishes to move forward today. Ms. Howard, does he still wish to move forward?
Decidido que él tiene que declararse culpable si quiere proseguir con este caso hoy aquí.
Or would he rather us reset further notice to a division judge?
O quiere que cambiamos el caso para que lo vea otro juez de la división.
So Mr. Ayala Gonzalez, the judge, is not going to allow you to enter a NOLO contingent plea in this case?
Señora Ayala,
Madam
González, señora Ayala, señora Ayala González, el juez no le va a permitir que usted se declare nulo en estos casos.
And so if you would like to resolve the case today, you would have to enter a guilty plea.
Si usted quiere resolver su caso hoy aquí, tiene que declararse culpable. Tendría que declararse culpable.
Or you could enter a not guilty plea and your case would be reset to one of the trial divisions.
O puede declararse no culpable y van a posponer su caso para otra jueces de la división de juicios.
And the state would like to note for the record that the state's recommendation is only valid for today.
Y la fiscalía quiere notar para que se conste en el acta de que la oferta que le están haciendo ahora es solamente válida por el día de hoy.
And Judge, you know, a NOLO appears on the criminal history just like a guilty does. People see it. He's served time for it. I mean, there's no real difference in terms of how it will impact him going forward, other than what he's explained in terms of his comfort level, given what he remembers.
Y que una declaración de nulo se va a ver igual en sus antecedentes penales que una de culpable y que refleja la forma que lo que él dijo que recordaba y cómo habían ocurrido los eventos.
So, well, he hadn't responded. I guess I need to let him respond. Mr. Ayala Gonzalez, are you willing to enter a guilty plea, or do you want to enter a not guilty plea and have the case reset to a trial division?
Señora Ayala González, ¿usted quiere proceder y declararse culpable o quiere que pospongan el caso para que se vean más adelante en la división de juicios?
Culpable.
Guilty.
All right. I'm going to ask you some questions to make sure this is voluntary.
Voy a hacer algunas preguntas para asegurarme que usted está haciendo esto voluntariamente.
Please raise your right hand.
Por favor, levante su mano derecha.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
¿Usted jura y afirma que el testimonio que va a dar aquí es la verdad según lo que usted recuerda?
Sí.
Yes.
Are you under the influence? You can put your hand down. Thank you.
Puede bajar la mano.
Are you under the influence of any drugs or alcohol at this time?
¿Usted está bajo los efectos de alcohol o de drogas en este momento? ¿Cuál es su respuesta? Yes.
He's under the influence of drugs?
¿Está usted bajo los efectos de drogas en este momento?
No.
No.
Do you understand what's happening today? Do you understand this proceeding?
¿Usted entiende lo que está ocurriendo ahora aquí? ¿Usted entiende todo este proceso penal?
Okay.
Yes.
All right, and did anyone force you to take a plea today?
¿Alguien lo ha forzado para que usted se declare de esta manera hoy?
No.
No.
Did anyone promise you anything in exchange for taking a plea?
¿Alguien le prometió algo para que usted se declarara de esta manera hoy?
No.
No.
And do you understand that by taking a plea today, you'll have no further court dates regarding this?
¿Y usted entiende que usted presentar su declaración aquí ya no va a haber más tiempo, más ocasiones que tenga que venir al tribunal? ¿Entendió eso? Yes.
All right, and you understand the requirements? You cannot go back to those locations or have any contact with those victims?
¿Y usted entiende los requisitos que se le exigen, que usted no puede volver a esos sitios que se mencionaron y tampoco puede tener ningún tipo de contacto con las personas que se mencionaron? Yes.
All right, as to the charges of loitering and prowling, Mr. Ayala Gonzalez, how do you plead?
En relación al cargo de merodear y holgazanear, ¿cómo se declara, señora Ayala?
Culpable.
Guilty.
I accept your guilty plea at this time, and I believe that concludes this matter.
I'm sorry, Judge. Did you read both charges?
I'm sorry, I said loitering and prowling and criminal trespass. I apologize.
sorry.
As to the charge, it's been a long day, I'm sorry. As to the charge of criminal trespass, Mr. Ayala Gonzalez, how do you plead?
Con el cargo relacionado a entrada ilegal o allanamiento de morada con fines delictivos, ¿cómo se declara, señora Ayala?
Culpable.
Guilty.
All right. Is there anything further from either party that we have not addressed as part of this case?
No, Your Honor.
All right. Best of luck to you, sir. And Madam Interpreter, you can be excused.
Thank you, Your Honor. Buena suerte, señor, y ya se terminó su caso. Thank you, Your Honor.
All right, have a good day. I believe that concludes the entire calendar. I apologize. That's why I usually say to the charges I previously listed because I don't always catch them all. I think we have the competency calendar is complete. The DV reset case, based upon the fact that he did appear today, the bench warrant will not be lifted. However, we will put him on for a DV reset calendar case next. Can we add that next week? And 11 o'clock next week, since he did show up.
And can the record reflect that he showed up an hour late?
Apparently there's some information from the clerk's office that it was the clerk's office's fault.
Mr. Jordan said he take responsibility.
Mr. Jordan said it was his fault. So I don't know. We're not gonna inquire
I'll
any
say Mr.
further.
Jordan at his word. We'll see.
So will I, because it is 1:30. So what we will do is we will have a DV reset case on next Thursday. Oh, it's Thanksgiving again.
Yeah, we won't be here.
I'm resetting him to myself, unfortunately. All right, 12-1, he'll come back here. But I won't, we're not gonna remove that warrant at this time. All right, that concludes the competency calendar. I don't think we need to review it.
No, are you, am I gonna see you at 2, Judge, or is
You
it?
will not see me at 2, it'll be Judge Winstead. All right, so y'all take care, have a great rest of your day. See you all on 12-1. All right, bye-bye.
Thank you.
Okay, bye-bye.